Morning, just keep your seats and number one. Okay, so as we jump in, obviously, as you can see, the normal PowerPoint is not up there. What I thought we could do this morning, for many of you all know, on December 29th, Deputy, or I guess Sergeant McIntyre with Spalding County Sheriff's Office was shot and killed while responding to a wellness check. What I wanted to do for us this morning is just have a minute of silence for him, and once we have done that, then we will resume our normal operations. So I don't know if you all know him or had an opportunity to interact with him, but to tell you just a little bit about who he was the kind of guy where a lot of people at the funeral were wearing Hawaiian shirts because that's who he was. He loved being big and loud and noisy and colorful, and this is a great loss for Spalding County. He's also a vet. He served in our Army, and so it's a loss for our country as well. All right, I'm going to turn on my timer, and we are going to have a minute of silence starting now. I'll ask you to hold the door, Clint. All right, thank you all. April, I've turned my phone off. You should do the same. Okay. All right, so if you all will please look up at the monitors, I'm going to go over your rights with you, and we're going to get this calendar moving forward. So this is the Spalding County State Court. My name is Josh Thacker, I'm your judge, and this is the bonded trial calendar call. I want to start out by saying that here in the Spalding County State Court, we believe that each of you, as you interact with this court, deserve the respect and the dignity that you wish for someone you care about. We will extend that respect and dignity to each of you as we interact with you all here today. Please do not talk during court. Our goal is to move your case forward appropriately, get you back to your lives as soon as possible. I cannot do that if you're having sidebar conversations, and frankly, you will find very quickly that I have no patience for it. All right, I do not have anyone virtual here. Thank goodness. All right, cell phones. So, as I said a moment ago, please pull your phones out from wherever you have stashed them, pockets and purses, and check them and make sure they're off. Every day somebody's phone rings, and then I have to have a contempt hearing. Please do not volunteer for that contempt hearing. Just check your phones right now. Absolutely make certain that they're off. If it rings after this, it means you've ignored my instructions to check your phone and make sure it's off. Okay. All right, this is the correct courtroom for you. If you were arrested on a misdemeanor here in Spalding County, you appeared or waived your arraignment date, you requested a trial, you were here today. If this sounds incorrect, step out into the hallway, speak with the bailiff out there, show them your paperwork, and they will move you in the right direction. Is there Superior Court going on?
There's Judge Tucker has, civil today.
Oh, civil, okay. All right, today is what's called your calendar call. I'm going to go over your rights with you, and I'm going to tell you what your options are, and then you, or if you have an attorney, your attorney will tell me what to do with your case. You may have a trial. There are two types of trials. There's a jury trial where 6 jurors sit in that box over there to decide guilt or innocence on each of your charges. And then there's a bench trial. That's where you give me permission to make the guilt or innocence decision with no jury present. You may have a conference with the solicitor's office if you're representing yourself, and you can ask me about having an attorney, and we will have that conversation. Ms. Karen is here from our Veterans and Mental Health Court, also known as our Accountability Court. So if you are a current member of our military, or you are a military veteran, or you have a mental health diagnosis, and you wish to have your case dismissed, then if you're representing yourself at the first break, speak with Ms. Karen, see if you are a candidate for our court. If you miss the chance to speak with her, ask for a conference with the solicitor's office. They'll explain the program and help you see if you are a candidate. If you're represented by an attorney, and there's plenty of attorneys here, simply speak with your attorneys. They are very familiar with our program. All right, everybody's charges in this courtroom are misdemeanors. The average misdemeanor carries a maximum punishment of 12 months to serve in the Spalding County Jail and or a $1,000 fine. A few minor traffic charges like seatbelt have a lower maximum fine, and a few high aggravated misdemeanors have up to a $5,000 maximum fine. You have the right to a speedy and public jury trial, where 6 citizens of Spalding County decide guilt or innocence on each of your charges. Again, you can also choose a bench trial. That's where I make the guilt or innocence decision with no jury present. You can waive your right to a trial and close your case with a plea if you so choose. I have no preference. You must knowingly, voluntarily, and intelligently choose for yourself. Now, you have the right to be presumed innocent. You have the right to force the state to prove your guilt beyond a reasonable doubt. You have the right to cross-examine the state's witnesses, to subpoena your own witnesses and evidence to court. You have the right to testify or not testify. You have the right not to incriminate yourself. If you choose to remain silent, your silence cannot be held against you. You still have the right to have an attorney. You may still hire your own attorney here, and there's plenty of private attorneys here who I'm sure would love to have that conversation with you. Now, if you cannot afford an attorney, then you should have applied on your arraignment date in the courtroom with the public defender's office like I asked you to. I warned you on that date that if you did not take action ASAP to secure the public defender's office, you would very likely hear me say today that you have waived the right to apply. But if you still want to have that conversation, we still can. All right. An attorney would help you understand our criminal justice system, would explain what your charges are and what the defenses are to those charges, would file motions on your behalf, engage in plea negotiations, subpoena witnesses and evidence for your defense, conduct a trial on your behalf and make objections, protect your record and appeal a conviction, and otherwise work to protect you. All right, it is my responsibility to explain first offender and conditional discharge. These each allow you to enter a guilty plea without being convicted. However, you only get one of each for your entire life. First offender is for everything but traffic-related charges, so no DUIs, and the conditional discharge is for drug-related charges only. All right, no low contender A and traffic charges. We call this a no load plea for short. It's where you enter a guilty plea without admitting guilt, and it is available on most traffic charges and no DUIs. You get one no low every 5 years, and that is measured from the incident date to the incident date, ticket date to ticket date. A no load will usually prevent points. It'll usually save your license. It won't help you much if you're under 21. All right. If you are here today and you are not a United States citizen, you need to know that any conviction will very likely have a negative impact on your immigration status. All right, there are several of you on this calendar who are charged with family violence charges. It's in the title of your charge. If that is you, and if you are convicted of that family violence charge, you will lose any Georgia weapons carry permit you may have, and federal law will step in and say you may never again possess a firearm or ammunition. All right, it is my job to explain this weird old law called habeas corpus. We've all heard the term. We call it a habeas for short. So if you are convicted, you may sue Spalding County civilly over in Superior Court to challenge your conviction. Yeah, it's weird, but it's what it is. All traffic charges have a 6-month window to use those rights before they expire. Everything else in this courtroom has a 12-month window, and that's what I need you to remember. It's 6 months for traffic charges, 12 months for everything else before those rights expire. All right, you may conference today with the solicitor's office. If you are representing yourself, then you'll announce conference when your name is called. You'll remain here in the courtroom. If you, and you'll get a chance to meet with the solicitor's office, again, that's this group up here to your left. They represent the state of Georgia. They are not your attorney. If you reach an agreement, you can resolve your case with them. If you do not reach an agreement, then you must return to this courtroom for me to personally give you your next set of instructions. Attorneys, that does not apply to y'all. Just make certain that if you don't reach an agreement, you sign a verdict form with the solicitor's office. That's all I need. All right, for you all though, self-represented, you'll have to talk to me and I'll get your verdict form signed on the record. All right, if you receive probation today, you'll be supervised by Spalding County Sentence Enforcement. There'll be a one-time $25 intake fee. 100% of all fines may be worked off with community service work at a rate of $10 per hour. Additionally, there's a $50 per month supervision fee each month until you complete your probation. Now, the fee is mandatory, but it can be waived after a separate hearing before me. Okay, this is a 2-week trial calendar. So what that means to you all is that we are all the trials, jury and bench, are together on the same calendar. This is week 1, and this is calendar calls. And we've got another group coming in Tuesday and another group coming in Wednesday. Then we're all going to skip a week in the middle and do some other court and prepare for trial. And then at the beginning of week 2, we will begin your trials Monday at 9 a.m. sharp. I believe that's the 16th. Actually, is it the 16th?
Tuesday the 16th.
Yeah, Tuesday the 16th. So I always do this every January. So it's Tuesday. So it's not Monday because Monday's MLK. So that we start our trials on Tuesday, the day after MLK, the 16th.
Next week, okay.
So
Tuesday the 16th, tickets. I hope.
I think I messed up.
23rd is trial.
Yeah, I messed up. Okay. So y'all got this. Miss Kathy took this down. Y'all get a copy of the transcript if you want it. I made my first mistake ever. She'll file it with the clerk's office and y'all can all get a copy. Okay, your trials will start. Let's back to the normal. Your trials will start Monday, January 22nd at 9 a.m. is what's on the papers you signed. For those of you that need trials, and it's the week of the 22nd. Thank you, everybody. We will use two courtrooms that week, and we will reach your case for trial. And again, that's the week of Monday, the 22nd at 9 a.m. Sharp. Okay, we are still a small enough community where everybody knows somebody who knows everybody. So if you recognize a name that is missing, call them, tell them to get down here ASAP. I'd much rather they walk into this courtroom than me have to go see them out in jail. You will definitely save them a great deal of future trouble if you give them a call. All right, so you must let me know if there are any outstanding pretrial motions, speedy trial demands, or anything else outstanding that I need to factor into the trial of your case. Failure to give me this information or a bench warrant on your case will result in automatic waiver. All pretrial matters must be heard on the first calendar or they are waived unless I specifically preserve them on the record in open court. All right, so this slide has had all kinds of titles, and I just finally went with this important because that's just the easiest way to let you all know that, hey, this is important. So here's the deal. If your announcement is jury trial or bench trial, you need to know that what you're communicating to me is you do not want a conference. You do not want an attorney. You do not want a continuance. You do not want to enter a negotiated plea. You do not have any motions to be heard. You are just simply ready to pick your trial because this is the last opportunity to explore those options. I have zero intentions of exploring any of those options when I have a jury standing outside those two doors coming in to try your case. That's the whole purpose of calendar call. All right, so I'm about to call the calendar. When you hear your name called, no matter who you are, stand up if you are able. If not, wave your hand real high. Once you're up, if you have an attorney, remain silent and let your attorney announce for you. If you do not have an attorney, then you're going to very loudly announce with one of the following. So you'll stand up if you're representing yourself and you'll say jury trial real loud, or bench trial, or conference, or attorney, and do you have any motions? Okay, any housekeeping? Who's in jail?
You want to go over them now?
Yeah.
First page, page 1, Rodriguez Berry.
And Barry's got a fourth case, Judge.
Okay.
Calling him. It's a 22 TK 3755. It's traffic stuff.
Thank you. Okay.
Page 2, Melissa Ivy 2.
She's still in jail?
She,
Yeah, we received the order back
I
in
signed
August, and she's still there. They
if
said they'll
she's
get
in,
to
it's
her.
not on my signature.
No, you signed
They
yours.
just haven't picked her up yet.
Oh, okay.
Alright, so that one,
Wow.
Yeah, I was kind of surprised with that too.
yeah,
Let's,
that was
let's have a
it.
meeting about that and see if there's. anything
There's
we
two
can
of them that haven't picked
There's,
her up.
there's nothing.
do. We're just waiting on them to
You
pick.
don't have any, you don't have any debt
There's nothing I can do.
Yeah, because your order was signed months ago.
Let's go.
It was August.
in August.
Yeah, she's probably in a holding pattern waiting to go.
That hurts my soul. Okay.
It's not us.
No, it's, yes, we can.
Don't be mentally ill in Georgia.
Yeah,
Unless you're ready to wait.
we need to do more. All right, who else?
Page 7, Angelina Little.
She's not yours.
No, sir. This one's got a big question mark because it doesn't have a middle name. It's Justin Thompson, but we have a Justin Jamal Thompson that's in jail. So I'm not 100% sure if that's the same two people. Do we have a name for it?
I don't know, my
Are
fault.
you Justin Thompson? He's raising his hand.
Oh, it definitely.
What's your middle name? Blake? Well, I only have one Justin Thompson, so I'm gonna go with Justin Blake Thompson.
Yeah, I'll take those bets.
Hey, y'all.
Yes, he's up. And he's yours?
Yes.
Right. And then we'll fix him in the system so that his middle name shows up.
And I haven't made it all the way to the end, but when we get to their name,
Yeah.
I'll let you know.
That's fine, just jump on this one. All right, Ms. Shepherd, anything?
Yes.
Just one more? No. All right, let's call again. All right, first case on the calendar, 2 cases, William Arnold.
He's in accountability court.
Oh, that's right.
Yes.
I'll take you, Mr. Murray. All right, Christopher Barkley. All right, he's here.
Calvertron.
Thank you. All right, Barry's in jail. See him on Wednesday. Yamika Brown. Brown? Oh, yes, ma'am. Conference, thank you. All right, let's go on. Azalea Brownlee.
Conference.
Conference, thank you. All right, Alyssa Cook. I don't need to see her Wednesday. I'd love us to talk, but I don't need to see her on Wednesday, so.
Yeah, I know you've signed the order. I've seen it. It says she was in
I wouldn't do you any good if you tried.
No, we wouldn't. So, we need to do more. We, Georgia, need to do more. Dwayne Counts? That's yours? He's here.
Calvertron.
Thank you. All right, Darius Dennis. Good morning.
He's out.
Calvertron.
Okay. All right, all 3 are checked. Tracy Dykes?
Young, I think we have to negotiate a plea. I need to see Patrick and get the plea papers signed.
All right, thank you, Mr. Kramer. I'll get that. Oh, it's 2 cases, okay. All right, Burnett Elliott.
Yes.
All right, he's here.
Calvertron.
All right, thank you. All right, Nicholas Fryer. Let me see Mr. Moody. Let me figure out where Mr. Moody is. Sit tight.
There
I think I
was a
saw
flood of conflict.
Yeah, I saw it. I got a pile that I haven't even looked at, so.
Thank you.
Has he given you, has Mr. Moody given you any indication of when he might be here?
I text him Saturday. That's how it's up to.
Okay. All right, just sit tight. In fact, if you want to step out in the hallway, call his office and see if they can give you an ETA. I don't want you sitting here unless there's some indication he's on the way.
Oh, yes.
All right, Jennifer Berner.
Good morning, Myra. Expect to negotiate a plea this morning. I said, I'll get some paperwork, Mr. Shepherd.
All right, thank you. Jeffrey Gilbert.
He's y'all.
Yes, he is.
We think he-
question he might be in state custody.
The state system, you revoked him
Yeah.
a significant amount of time on several probation cases, but he also had a couple felonies pending.
Well, if we're unsure.
So we just
I would
asked for a
say-
bench warrant and no bond forfeiture.
Yeah,
But I believe,
there's no harm in that if we're wrong. So, okay, so this one will be a bench warrant, but no bond forfeiture. And I'm just gonna put system question mark. All right, Ms. Clark, this one's you, Whitney Hall. Whitney Hall,
Judge, we'll do a
conference on that, let me see if I can find her, because I didn't have that on my calendar, so she may have got it.
Yes.
Market?
Yeah, well, that's for bond forfeiture and benchmark.
That's great. Let me know when you get it sorted out. Chantelia Howard? Howard?
Their response. That's for bond forfeiture and benchmark.
Great. Jarvis Jackson? Jackson? No?
That's for bond forfeiture and benchmark.
County, that's not rotational.
That's yours as well, I guess. All right, I got that.
Yes.
All right, Stephen Jeffcoat. All right, thank you. Right back to you, Mr. Malloy, Satorian Jester. Jester? No?
Your Honor, we understand Mr. Jester has a very serious felony charge that he's out on bond on.
He got a bond and a murder.
I didn't want to say it that way.
Well,
I'll say it. Yeah, he somehow got a bond on the murder. So we asked for a bond forfeiture and benchmark on all 3 cases.
and I'll do something they won't do. That's the whole bit I want.
Thank you.
So, no.
Get a bond and a murder, and then you get locked up in misdemeanor.
Oh, he's got one.
You got 3.
Okay. Oh, he would have been no bond anyway, so it would have been automatic in 2 cases. Okay. Warrants on all 3. Jesse Jimerson, that's also you, Mr. Malloy. He's here.
Conference, Your Honor.
Thank you. All right, Robert Lawson. Robert Lawson. That's also Mr. Mays. Let's put Mark here.
That's for bond forfeiture and benchmark.
Good. All right, Littles is in jail. Dexter Mangum. Mangum?
You all right? I think that's another case that the state is not for us.
Oh,
Yes, Judge, they filed a plea and bar on that. It's a theft case that's related to a felony case, which he has resolved the felony cases. We went back and looked at it. It's the same incident date. It's a valid plea and bar that they filed, so we'll be filing a dismissal on that.
all right. All right. Mr. Well, I see here on Jonathan Martin.
Yeah, good morning, Your Honor. Ms. Miller is conflict. I'm here to compensate on that, otherwise we would.
Cedric Mays. Good morning. Thank you, conference. All right, Troy Middleton. Troy Middleton? No?
That's for bond forfeiture and benchmark.
Actually, you want to do that still? You said you want
Is that yours?
Yeah.
I'll just put them in for conference.
Oh, I did, yeah, we'll be dismissing that case.
Thank you.
I withdraw.
And that was Cedric Mays, right?
That's
No.
That's right.
That was Middleton.
Lakeville, Troy Middleton.
My notes in my pad, my notes in my calendar hadn't caught up with each other.
All right, Cedric Mays was over here somewhere. Conference, right? Okay. Sorry, Mr. Mays, I got you mixed up. Okay, Keisha Middleton? Keisha Middleton, that's also yours. Is that related or anything?
No, that's, well, that's for bond forfeiture and benchmark.
All right, great. Let me know if you find your client. All right, Mr. Hutchinson, over to you. Sean Morris.
It's present, Your Honor. It's going to be a plea, negotiated plea. Just need to get the paperwork.
Okay, sounds great.
Get it written
Back to you, Mr. Hutchinson. Christopher Pemberton.
Your Honor, I believe the state was on dead dock with that case.
Yes, Judge, he's, some serious medical / mental health issues on that one.
Okay.
We had continued it to this date to let them get the paperwork. I believe he's had a guardian appointed,
Okay.
and so we're just gonna be dead docketing that. We'll get an order to you shortly.
All right, back to you, Ms. Clark. Christian Pitts.
Let's have a conference.
And he's here. Thank you. Valkyrie Shannon, Mr. Malloy. Shannon, no movement.
That's for bond forfeiture and benchmark.
Great. Brittany Shivers or Shivers? Shivers, you're here? Conference. How do you say it?
Shivers.
Shivers. Okay. Stuart, back to you, Ms. Clark. Stuart Smith. Stuart Smith.
Judge, I will try to find him.
Okay, put you down for a conference and
We'll ask for bond forfeiture and bench warrant.
we have the one. I'm sure this will be easy to swear out. Chandler, Turquino? How do you say your last name? Turquino, okay.
Conference.
Okay.
Judge, there's a write-in on this page.
Okay.
It's Edward Robbins, Mr. Harding's case, 22 SR 1922. It's just a law firm. They just want to resolve it, so.
Okay.
So, Mr. Big, good morning.
Negotiate it, please.
Okay.
He'll still need me probation. I believe he's done that
That's
yet.
fine. We'll pass this on to you. This page is ready. I think we just go to your application.
Yeah.
To do the intake sheet. All right, we've established that this is Justin Blake Thompson who's here.
And that's
And Michelle.
conference, yes, sir.
Okay, conference. Mercedes, Tuala.
She's here. Conference, Your Honor.
Okay. Lamont Trice. Looks like maybe 2 cases.
He's in the hallway, he was late.
Okay. All right, I'm gonna mark it as a warrant, since he's late. I'm gonna mark it as late, so he's used as one left. Everybody got that, so.
Yes.
Warrant left. Burns it. All right, Ms. Clark, back to you, Richard Tucker. Perfect, thank you. Devon Williams. Good morning. Conference, thank you. Back to you, Ms. Clark. Megan Williams.
But she's in accountability court.
She was the one,
She's in Macon.
yeah, she was the one we were trying to get transferred down to Macon.
Yes,
Remember that?
yeah, because Leslie was swapping emails with you, so. Okay, well, y'all just let me know what you need on that.
I think that all got resolved. I think this is just,
Yeah, my understanding was, I remember Leslie telling me when I passed her in the hallway somewhere that we're good. That's all I've got. So, and all I knew is that it was the Macon case, not this case.
yes.
And that was all, none of that was Miss Williams' fault.
Yeah.
We were waiting on Macon to get back
Yes.
to it, and that,
That was my context of it as well. Okay, Mr. Lee, Michael Wilson,
Judge, it should be a negotiated plea. We just need to take work from that.
sounds great. David Wright. David Wright? No?
well, that's for bond forfeiture and bench warrant.
Granted. Mr. Abbott, Zapata Ricardo?
He is present, Judge. We have for conference.
Okay, thank you. Okay, so that's the calendar, so a couple of announcements. Are there any witnesses here? Any witnesses that need to be here? All right, so 2 to 3. I'll give y'all will get directions in just a moment, from the solicitor's office, so y'all just know that they'll come back to you in just a second. Anyone else here other than y'all whose name was not called, stand up for me. There's usually a good handful. All right, now, a couple of them I think are y'all's.
Judge, I've got Baldwin Moultrie. He's here.
Moultrie, you sit down. You're good. I got you. You're in hand. All right. What's your name? Nice and loud.
Carl DeMarco.
All right. Mr. Marco, what are you charged with?
I think disorderly,
Reckless conduct.
reckless conduct, is that it? I'm sorry.
It's 23 SR 0684.
I think he was supposed to be here previously.
Oh, okay. Y'all had talking to him.
We've got it written up.
Okay. All right. Grab a seat. They'll talk to you and give you directions. Nice and loud. What's your name?
Nathan Williams. Judge, it's one of ours, too.
Okay. Grab a seat. You're in hand. What's your name? Nice and loud.
Wayman Colbert.
Colbert. What are you charged with, Mr. Colbert?
Simple bad.
I don't see him on this week.
No. This is the moment where I get to say, Justice, the name of our new database, is slow today. So, they just need to pick, we need a new naming committee.
It's
Because
22 SR 1186.
22 SR.
And I'm showing these down to.
It's just not on here.
Except for today.
It is.
How did it get
for conference, okay?
He goes to the bathroom.
Okay, I was about to say, I was looking at an empty seat there. All right, is there anyone else whose name was not called? Did I miss anybody? All right, and all of y'all's cases were called, everybody's in hand? Okay, Mr. Shepherd, the floor is yours.
All right. Did you see it?
Yeah, it's in.
Oh, yeah. Okay, we pulled it. I don't know it.
I do believe, I think, I'll take it.
All right, good morning, y'all. I'm Patrick Shepherd. I'm the solicitor. That means that I'm the prosecutor. This is Jackie Tony. She's the other solicitor. We're the ones that do the conferences this morning. If you have an attorney, follow your attorney's instructions for the rest of the morning. We'll meet with your attorney, give them a plea offer, they'll convey that to you, and go from there. So just follow the instructions the rest of the morning. If you do not have an attorney and you ask for a conference, what's going to happen is either Ms. Sharon Middleton there with the beige and brown squiggly sweater, or Miss Lenise Fletcher over there in the black sweater. We'll call names. When they call your name, you're going to fall through the double doors over here to my right and your left. There's a hallway, leads to a waiting area outside of my office. Go back down there, have a seat in one of those chairs, and myself or Miss Tony will call you back for your conference. When you're done for your conference, come back to the courtroom through the same double doors, quietly have a seat in the courtroom. Don't use the single door over there next to Mr. Lee. If you come through that single door, you will disrupt court, make the judge unhappy. Not a good way to start your week. Obviously, there's a lot of y'all and only 2 of us, but we know what we're doing. We do this pretty much every day. We move quick. We'll have everybody out of here at a decent time today. If you are a witness, who was witnesses? Okay. All right, if y'all will hold tight in just a few minutes, Miss Lenise Fletcher over there, we'll get you a Sherry one, we'll get your names and numbers, and then we'll put you on call if we need you for a couple of weeks and let you get out of here today. Attorneys, y'all obviously got us badly outnumbered, so if y'all hang out here in the courtroom, we'll call you back, go through your cases. I'll try and get the ones that just have 1 or 2 first, get y'all in and out. What the y'all that have multiples, just hang on a minute, we'll get to you, all right? Thank you.
All right, Mr. Moore.
Just back.
In there.
Yep. Good morning. My name is Terrence Malloy. To the left, my partner, Mr. Harry Shawley. We're the 2 attorneys that represent the Juice Funds, the public defender's office. For all those of you that we already have tape files on, you know this chair, and this call, we said conference. That means we've already pre-tried your case, and we'll have updates for you about your case. When we take a break, and we'll call you back individually, and speak to you about your case. For those of you who, well, actually shouldn't be what happens is if I call your name and you're not here when I call your name, I'm gonna go do this. And Mr. Charles will do the same thing, keep on the power. Guess what? You gotta wait till you come back through it. If we do this a second time, we call your name twice, you go to the bottom of the pile, you have to address Judge Stacker at that point. The reason why I say that, he's gonna piggyback on what I'm about to say here. For some reason, almost every court date we do this, somebody comes in here, they show up, they say they're here. Then when it comes to us to call them so we can talk to them about their cases, they go somewhere. We don't know where they go. They're just not here. We don't know what to do about it. So the only option, as the judge said, is that if we do it twice, you get to address him. And then whatever he says goes. So help yourself with being present. It doesn't mean you can't go out to the bathroom or go downstairs, take a smoke, that's what you got to do. But please come right back. I'll keep saying when the judge left the bench, I thought I could be gone as long as he was gone. No, he's gonna leave the bench so we can do our work. Like Mr. Shepherd said, we do this all the time. We're really good at it. We get you out of here as fast as possible, but we can't do it if you're not present. So I guess I'll listen no more for that. But just be present when we call you and be helpful to all of us.
All right, I'm gonna say the same thing differently, which is that here's how my version of what Mr. Malloy says goes. You ready? One of you, statistically speaking, is going to volunteer today to go to jail. Let me say that one more time. One of you, statistically speaking, is going to volunteer to go to jail. Because one of you today, we're going to eventually call a name, and we're going to go, I don't know where that person is. Maybe you went and got a haircut. Maybe you decided you had time to change your oil or mow your yard. I don't know. But every single day, one person wanders away. And my solution to that is to issue a bench warrant for you, to no bond you, and then I will go see you at the jail because you clearly cannot be trusted to stay here in the courtroom as I'm instructing you. Because listen to these instructions. They're not complicated. You ready? Here's my instructions. We're all human. We've all had coffee. Go to the bathroom. Get back in your seats. We're all human. We've all had coffee. Go to the bathroom. Get back in your seats. That's it. That's my entirety of my instructions. But one of you today will go to jail. I'm so sorry. It's statistically speaking going to happen. Okay, That's it. So it's 9:40 now. I'm gonna step off the bench until y'all have several that are almost ready. Is that right? Okay, then I'm gonna step off the bench until 10:30. That'll give you all about 45 minutes to get your client signed up with probation, get a nice stack up here, and then that'll let you all get back and get settled. All right. You guys, anything else? All right. If you have questions, talk to the bailiffs. They'll take care of you. Ms. Melson, the floor is yours.
I just need the witnesses that
and I'm gonna just take this there. All right, Mr. Harding, I think you've got just one, right?
Yes.
Okay, we'll take yours first.
Mr. Rob,
Yes.
Robbins?
I think it's 22 SR 1922.
Oh, this is the add-on.
Yes, yes. He's right here.
Okay. So all looks good, right? Okay, Mr. Robbins, if you'll please raise your right hand for me. You solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, take your head down. State your full name for me.
Edward Lee Roberts.
All right, Mr. Robbins, you were here on 22 SR 1922. This is a ride-on case, and Mr. Harding has walked you in to resolve your case today. Is that correct?
Correct.
You were here on time for court today. Is that correct?
Correct.
Did you hear the rights I read out to the courtroom and see that PowerPoint that I put up on the wall?
Yes, sir.
Did you understand?
Yes, sir.
I'm holding up this written version of those rights, which is the attorney and defendant plea rights waiver. Do you recognize this document as the written version of those rights?
Yes, I do, sir.
Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
Is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time you needed to review it
Yes, sir.
and to ask your attorney any questions you have about it?
Yes, sir.
And because you understood everything that's on it?
Yes, sir.
Have you had all the time that you need to speak with your attorney about all aspects of your case?
Yes, sir.
Are you satisfied with the job your attorney has done on your behalf?
Yes, sir.
Do you understand that you have the right to a jury trial
Yes, sir.
and that by entering this plea, there will be no trial and this case will be closed? Is that what you want to do?
Yes, sir.
Do you have any questions for me about anything before I give it to Mr. Harding with my next set of questions?
No, sir.
Mr. Harding, do you stipulate that there's a sufficient factual basis for me to take this false report of a crime plea from February 4th of 2021?
Yes, I do.
All right, and Mr. Robbins, do you want to enter a guilty plea to that charge?
Correct, sir.
All right. I find between Mr. Harding's stipulations of the factual basis and Mr. Robbins' request to enter a guilty plea that there's enough for me to take the plea. I'm going to find that you are knowingly, voluntarily, and intelligently waiving your rights. I reviewed the recommendation and I'll follow it as it's been negotiated. Mr. Harding, the floor is yours if you want it.
We just ask you to follow the recommendation, Your Honor.
All right, I will happily do that. Mr. Robbins, do you have any questions for me before I sentence?
No, sir.
You ready?
Yes, sir.
All right, here we go. Edward Robbins, 22 SR 1922, from February 4th of 2021. Count 1, false report of the crime. I find you guilty. It's 12 months probation. $590 is your fine. You may work off your fine with community service work. Show you valid license to probation. No alcohol, illegal drugs, or hemp products should be tested for those. Fourth Amendment waiver, $50 per month supervision fee, $25 one-time intake fee. In this case, will close the moment you satisfy your obligations to the court. You have 30 days from today if you wish to appeal this decision, and you have 12 months from today if you wish to use your habeas rights. All right, any questions about anything before you and I part ways?
No, sir.
Mr. Harding, anything else?
No, sir.
Mr. Last case, right?
Yes.
Okay, good to see you.
You too.
Mr. Clint's gonna walk you out those double doors back there and have you go meet with the probation.
Yes.
All right, return it. record. All right, so Ms. Gerner, what we're gonna do is I'm gonna just pick this document up here. So this is now the attorney and defendant plea rights waiver, which is virtually identical, other than, of course, this version says you're happy with the job your attorney has done. Do you recognize this document?
Yes, sir.
Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2,
Yes, sir.
is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it?
Yes, sir.
And because you, and having a chance to ask your attorney any questions that you have about it?
Yes, sir.
And because you understood everything that's on it?
Yes, sir.
Have you had all the time that you need to speak with your attorney about all aspects of your case?
Yes, sir.
Are you satisfied with the job your attorney's done on their behalf?
Yes, sir.
You understand that you have the right to a jury trial,
Yes, sir.
and that by entering this plea, there will be no trial, this case will be closed. Is that what you want to do?
Yes.
Do you have any questions for me about anything before I pivot to your attorney with my next set of questions?
No, sir.
All right. Mr. Sullivan, do you stipulate that there is a sufficient factual basis for me to accept count 1, this DUI plea, from February 4th of 2023?
Yes, Judge.
And Ms. Gerner, do you wish to enter a guilty plea to this, it's DUI less safe. Do you wish to enter a guilty plea to this DUI less safe charge?
Yes, sir.
All right, moving on to count 4. Mr. Sullivan, do you stipulate to the factual basis for the failure to maintain lane charge?
Yes, Your Honor.
And do you wish to enter a guilty plea to that charge now?
Yes, sir.
Okay, I'm gonna find between the stipulations to the factual basis and the request to enter the guilty pleas that there's enough for me to take this plea. I'm gonna find that her plea is knowingly, voluntarily, and intelligently being entered, and that she's waiving her rights appropriately. I reviewed the recommendation. I'm gonna follow it exactly as it's been negotiated. Floor is yours if you have anything you wish to add.
Thank you, Judge. She did go into a residential treatment program shortly after this arrest. She still attends AA regularly. She does appear to qualify for a permit referral form. I'm not sure. It's been a while how we get that from the court.
So we, I'm just gonna say out loud, we did a new thing during COVID, and it worked so well, we haven't struck back. So what we did was to reduce all the paper that had COVID that was being passed around and contact points.
Yes.
We just simply said, if your address is correct on your license, which it should be by Georgia law, then you're gonna get a letter in the mail from DDS in about a week or so, because we report it immediately. And so we'll have it to them within 48 hours.
Yes.
DDS will send you a notice, then you need to take action. And your attorney has the automated line. If you ever get nervous and you just want to call, make sure you're good, call the automated line. But you'll take care of that with DDS, correct?
Judge, I did go over that possibility with
Yeah.
Mr. Shanks.
So that seems to work pretty well for us, and we're happy with it. DDS has not given me any sort of nasty gram, so we're going to keep going this way.
Yes, sir.
Okay. Anything else?
No, Judge.
All right. Matt, do you have any questions before sentence?
No, sir.
You ready?
Yes.
All right, here we go. Jennifer Garner on 23 SR 0632 from February 4th of 2023. Count 1 DUI. This is the less safe. I'm going to find you guilty. It's 12 months probation. 1671 is your fine. Count 2 will merge into count 1. Count 4, failure to maintain lane, is guilty. 12 months consecutive. $300 is your fine. That's a total of 24 months of probation. Counts 3, 5, 6, 7, and 8 are dismissed. 1 day to serve in the Spalding County Jail. Credit for time served. You will not have to go back. You may work off your fine with community service work. Show your valid license to probation. No alcohol, illegal drugs, or hemp products. You will be tested for those. Fourth Amendment waiver, $50 per month supervision fee, $25 one-time intake fee. Once 12 months have passed, no violations have occurred, and all conditions have been met, I'll let your case go to non-report. The conditions that you must complete to achieve that include 40 hours of community service work at a rate of no less than 6 hours per week. You must complete a substance abuse evaluation within 90 days. You can submit, I assume there was an evaluation when she went in.
Yes.
Submit that to them. If it applies to where we're at, it'll probably work, but I'm gonna let them read it and make a recommendation to me as to whether to accept it or get it.
Thank you.
So, but it can't hurt to submit it to them. DUI school, either complete it or show a certificate of completion. That's the sentence of the court. You have 30 days from today if you wish to appeal this decision. You have 6 months from today if you wish to use your previous rights. All right, do you have any questions for me at all, ma'am?
No, sir.
All right, anything else?
Judge, once I get over to probation, may I be excused?
Yes, it's good to see you, by the way. Oh, here, come up here just a second. Who's yours?
Me?
Good.
He's a potty.
All right, ready? Who's yours, Mr. Tanner? What's yours?
Tracy Dyke.
All right. All right, tell me how to pronounce your last name.
Zapata.
Okay, just go with Zapata. All right. Mr. Zapata, can you please raise your right hand? You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, take your hand down, state your full name.
Peter Zapata.
All right, Mr. Zapata, you are here on 22 SR 0401. According to my calendar, you were on time for court today, is that correct?
Yes, sir.
Did you have the right to go out to the courtroom and see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Mr. Zapata, have you, your attorney has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document that I'm holding up?
Yes, sir.
Are these your initials next to each of the lines on page 1?
Yes, they are.
Page 2?
Yes.
Is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you need to review it?
Yes, sir.
And having an opportunity to ask your attorney any questions that you have about it?
Yes.
And because you understood everything that's on it?
Yes, sir.
Are there any questions I can answer for you about anything on this document?
No, sir.
Have you had all the time that you need to speak with your attorney about all aspects of your case?
Yes, sir, I did.
And are you satisfied with the job your attorney has done on your behalf?
Yes, I am.
Let's go off the record. Let's go back on record. Okay, I was talking through some logistical questions with Mr. Abbott. All right, Mr. Zapata, have you had all the time that you need to speak with your attorney?
Yes, I am, sir.
Are you satisfied with the job he's done on your behalf?
Yes, I am, sir.
Do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial, this case will be closed. Is that what you want to do?
Yes, I am, sir.
All right. Do you have any questions for me about anything before I pivot to your attorney with my next set of questions?
No, sir.
Mr. Abbott, do you stipulate that there's a sufficient factual basis for me to accept this expired license plea?
I do, Your Honor.
All right. I find that, and do you wish to enter a guilty plea to this expired license charge?
I do.
All right. I find between the attorney's stipulations and the defendant's request to enter a guilty plea that there's enough for me to take the plea. I'm going to find that Mr. Zapata is knowingly, voluntarily, and intelligently waiving his rights and entering this plea. I reviewed the recommendation, and after asking the attorney a couple questions off record about it, I'm gonna follow it as it's been negotiated. Floor is yours.
Judge, I think the court was tweaking the probation if he fails to pay within 30 days. If he pays within 30 days, there is no probation, and therefore there could not be any immigration consequences.
That is correct. So I just added an extra layer to it, just to be careful.
Yes.
So, okay. All right, Mr. Zapata, do you have any questions for me before I sentence?
No, sir.
Okay, here we go. Mr. Zapata, on 22 SR 0401, from June 6th of 2020, count 1, expired license, I'm gonna find you guilty. It's 11 months probation. Is it 945.50? Was that?
Yes.
Okay, 945.50 is your fine. That's a total of 12 months probation. Counts 2 and 3 are dismissed. I'm gonna delay the start of your probation by 30 days. Which gives you 30 days to pay the fine in full plus a $30 program fee for our 30 for 30 program. If you're successful in that, then your case will close. If you're not successful, your probation will begin 31 days from today automatically. At which point, you will need to show a valid license to probation, have no alcohol, illegal drugs, or hemp products, and you will be tested for those. Have a Fourth Amendment waiver, $50 per month supervision fee, $25 intake fee, and your case will still close the moment you've satisfied your obligations to the court. You have 30 days from today if you wish to appeal this decision, and you have 6 months from today if you wish to use your habeas rights. Okay, any questions for me about anything before I sentence? Before we part ways?
No, sir.
Yes,
Judge, just to be very clear, if he pays on or before February 8th, he is not sentenced to probation, correct?
that is correct. The whole goal is to avoid probation.
Yes.
So, all right, and that is exactly why well, not for this purpose, but that is exactly why we set it up that way.
Yes, Your Honor.
Thank you.
Okay, anything else?
I ask to be excused.
Good to see you. Thank you. All right, Mr. Kramer?
Tell me to give you this.
All right, is it Tracy Dykes?
Yes, sir.
All right, Ms. Dykes, please raise your right hand for me. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but truth, so help you God?
Yes, sir.
All right, take your hand down, state your full name for me.
Tracy Elaine Dykes.
Ms. Dykes, you have 2 cases on the calendar today, 22 TK 5464, which it looks like is going to be dismissed pursuant to plea negotiations. Then we're going to enter a plea on 23 SR 0778. Is that your understanding?
Yes, sir.
All right. You were here on time for court this morning, is that correct?
Yes, sir.
Did you hear the rights I read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Any questions I can answer for you about those rights?
No, sir.
Your attorney, Mr. Kramer, has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document that I'm holding up?
Yes, sir.
And do you recognize it as the written version of those rights I read out earlier?
Yes, sir.
Are these your initials next to each of the lines on page 1,
Yes, sir.
page 2?
Yes, sir.
Is that your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it
Yes, I did.
and to ask your attorney any questions that you have about it?
Yes, I did.
Have you had all the time that you need to speak with your attorney about all aspects of your cases?
Yes, sir.
Are you satisfied with the job your attorney's done on your behalf?
Yes, sir.
You understand that you have the right to a jury trial,
Yes, sir.
and that by entering this plea, there will be no trial, and this case will be closed. Is that what you want to do?
Yes, sir.
Ms. Dykes, do you have any questions for me about anything before I pivot to your attorney with my next set of questions?
No, sir.
Mr. Kramer, do you stipulate that there is a sufficient factual basis for me to accept this reckless driving plea from November 28th of 2022 here in Spalding County?
Yes, sir, Your Honor.
All right, and do you wish to enter a guilty plea, ma'am, to that reckless driving?
Judge, could we ask for a no-low, because she is really gonna have a hard time with insurance.
So, let me see. Let's go for it. and 23 SR 1110. And then we also have 22 SR 1178, but that's going to be dismissed at the end of this pursuant to clean deficiencies. You were on time for court today, is that correct?
Yes, sir.
Did you hear the rights I read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Your attorney has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document as the written version of those rights?
Yes, sir.
Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
Is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it
Yes, sir.
and to ask your attorney any questions that you have about it?
Yes, sir.
Are you, have you had all the time that you need to speak with your attorney about all aspects of all of your cases?
Yes, sir.
Are you satisfied with the job your attorney's done on your behalf?
Yes, sir.
Do you understand that you have the right to a jury trial on each of your cases?
Yes, sir.
And that by entering this plea, there will be no trial and this case will be closed? Is that what you want to do?
Yes, sir.
Mr. Charles, please step up here real quick. Okay, thank you, Mr. Charles, for clearing that up for me. Okay, so, do you have any questions for me, sir, before I pivot to your attorney with my next set of questions?
Once I pay the fines, will my probation be terminated?
No, that was my question I was asking your attorney.
You have 12 months. To pay the fine because it's fine.
What I'm saying, if I pay both.
It won't keep you from asking, but it's not an automatic part of your sentence. Does that make sense?
My advice to him, once he gets his license, his Georgia license, then he can talk to probation about it. That might be considered.
Yes, I agree.
But you will need to get your license.
It's gonna be kind of difficult around it being that I wouldn't be able to do it unless I go to Florida.
Yeah, and probation's gonna work with you. I mean, citizen enforcement wants you to succeed here. They want you to get your license back. So, they're gonna assist you in any way that they can, get your license back. So, and again, I'm telling you that if you get all this stuff finished and I don't have any revocations, you should ask me to close your probation once you've done everything you're supposed to do. I'm not telling you I'll grant it, but I'm telling you I'd love for you to ask me that question.
Yes, sir.
Fair enough?
Yes, sir.
Okay. Is that a fair enough trade?
Yes, sir.
All right, so let's keep moving then. Mr. Charles, starting with 23 SR 1110, do you stipulate that there is a sufficient factual basis for driving without a valid license?
Yes, I do, Your Honor.
Do you wish to enter a guilty plea to that charge? Mr. Trevino?
Yes, sir.
All right, and then moving on to 22 SR 1179, count 2, driving without a license. Do you, from January 15th to 2022, do you stipulate to that one, Mr. Charles?
Yes, I do, Your Honor.
And is, and then Mr. Tarquino, is that a, do you wish to enter a guilty plea to that charge?
Yes, sir.
Okay. All right. I'm gonna find between the attorney's stipulations and defendant's request to enter a guilty plea that there's enough for you to take his plea. I'm gonna find that he's knowingly, voluntarily, and intelligently waiving his rights and entering this plea. I reviewed the recommendation and I'll follow it. Ms. Charles, floor is yours if you want it.
No, sir. No recommendation.
Do you have any questions for me that I can answer about anything before I sentence?
No, sir, you did that already.
Okay. All right, so we're gonna start, let's just do this numerically. 22 SR 1179 is the first case. Count 2, driving without a valid license, won't find you guilty. It's 12 months probation. $590 is your fine. On both cases, you may work off your fine with community service work. Counts 1, 3, and 6. 1, 3 through 6 are dismissed pursuant to plea negotiations. Show your valid license to probation. No alcohol, illegal drugs, or end products. You can be tested for those. Fourth Amendment waiver. $50 per month supervision fee. $25 intake fee. A one-time $50 restitution payment to Spalding County to offset the cost of your attorney. And 20 hours of community service work. All right, that closes out 1179. On 23 SR 1110, driving without a license, guilty, 12 months, $590 is your fine. Same options for working it off, same requirements for license, drug testing, and Fourth Amendment waiver. Another $50, so it's an additional, I need to be very clear here. The $50 per month supervision fee, because these two cases, they're concurrent. There's only one $50 per month supervision fee. But there are two $25 intake fees, because it's per case. And there are two $50 public defender restitution payments, because it's two cases. I want to make certain you understood. There was one of one and two of everything else. All right. And that's the sentence of the court on 23 SR 11. You have 30 days from today if you wish to appeal either of these convictions. You have 6 months from today if you wish to use your habeas rights. Your last case, 22 SR 1110, is dismissed pursuant to plea negotiations by Malcross. Signing that one as we go. That case is now. I might have messed this up. Okay, just to make certain I numbered these correctly. Everything is correct except I think the numbers.
Right.
The two pleas were to 22 SR 1179 and 23 SR 1110. 1110 was driving without a valid license from October 21st to 22. 22 SR 1179 was driving without a valid license from January 15th of 2022. And then the Nalpros is 22 SR 1178. Okay, that got me right. If you'll go with Mr. Clint, that was over. All right, cool. All right, this is a continuation of the plea that I took a break on earlier. And Sycus, I'm going to remind you that you're still under oath.
Yes, sir.
Okay. So where we were at was I had finished all the plea rights waiver. We had established the factual basis and that she wanted to plea. And that Mr. Kramer had asked for a no-load. I had told him off record that if he wanted that on this specific type of case, I would want a recommendation from the solicitor's office, and then you spoke with them. If you want to put that on the record, that would be great.
Yes, Your Honor, I spoke and he had no objection.
Okay, and I see now that the sentence sheet has been modified to reflect that a no-load is recommended by the state, and therefore I will be following the recommendation.
Thank you.
Okay. Ms. Dykes, any questions before I sentence?
No, sir.
Everybody ready? All right, here we go. Tracy Dykes, 23 SR 0778. From 11/28 of 22, count 1 reckless driving and we grant your no load. It's 12 months probation, $1,222 is your fine. Count 2 is dismissed. Show your Georgia driver's license to probation, no alcohol, illegal drugs, or hemp products. You can test it for those. Work off of 5 with community service work. Fourth Amendment waiver, $50 per month supervision fee, $25 intake fee, and 40 hours of community service work at a rate of no less than 6 hours per week. You have 30 days from today if you wish to appeal this decision. You have 6 months from today if you wish to use your habeas rights. The other case, 22 TK 5464, is a null pros pursuant to plea negotiations, and I'm signing that null pros as we speak. Erica, I just realized I put 23 on everything I've signed. I'm so sorry. We all do it, but I found that this year would be the year I didn't do it, and I already. Okay. Ma'am, do you have any questions for the department? Yes, sir. Mr. Kramer, anything else?
Yeah.
Great to see you, Mr. Kramer. Ms. Dykes, if you'll walk Mr. Flint out those double doors, it'd be great to see.
Thank you.
Thank you, Mr. Ryan.
What's next?
Dennis? Dennis?
All right, you are Darius Dennis.
Yes, sir.
All right, raise your right hand for me. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, take your hand down, state your full name.
I Darius Dennis.
Mr. Dennis, you are here today on 3 cases. You, it's 22 SR 1380, 23 SR 1104, and 1105. Looks like we're getting our pleas on 22 SR 1380 and 23 SR 1105, and then I'm going to dismiss 23 SR 1104 when we're finished. Mr. Charles, is that lined up?
Yes, sir.
All right, so, Mr. Dennis, it appears that you were on time for court today. Is that correct?
Yes, sir.
Did you hear the rights read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Your attorney has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document?
Yes, sir.
Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
Is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it?
Yes, sir.
And ask your attorney any questions you have about it?
Yes, sir.
And because you understood everything that's on it?
Yes, sir.
Mr. Dennis, have you had all the time that you need to speak with your attorney about all aspects of all of your cases?
Yes, sir.
Are you satisfied with the job your attorney's done on your behalf?
Yes, sir.
Do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial on any of your cases, and that all of your cases will be closed?
Yes, sir.
All right. All right, this works. All right, then. It'll work. Mr. Dennis, let's start with 22 SR 1380. We'll just do this numerically in order. Actually, we'll start with Mr. Charles. Mr. Charles, do you stipulate there's a sufficient factual basis for me to take this count 2 suspended license plea on this case from January 31st of 2022?
Yes, I do.
Do you wish to enter a guilty plea to this suspended license charge from January 31st of 2022?
Yes, sir.
All right, and then moving over to 23 SR 1105 from March 23rd of 2023. Mr. Charles, do you stipulate that there's a factual basis for me to accept this plea on the suspended license charge?
Yes, I do.
Do you wish to enter a guilty plea to that suspended license charge?
Yes, sir.
And then count 2, speeding. Mr. Charles, do you stipulate the factual basis for 77 and a 55?
Yes, I do.
All right, and do you wish to enter a guilty plea to that charge?
Yes, sir.
I'm required, if he hasn't been fingerprinted, I'm required to fingerprint him on these. Do you know, were you arrested on these or just cited?
I was arrested on the speeding and the suspended license.
Okay. What I'm gonna do is, I'm just gonna check the box here that says, I'm I'm just gonna check the box that says go get fingerprinted. If you're already fingerprinted, you don't have to worry about that.
You get fingerprint you went to the jail.
Yes. Okay. All right, that'll be easy. Okay. All right, Ms. Charles, floor is yours if you wish to add anything.
No, sir, except to accept the plea recommendation.
All right, which I will do. Mr. Dennis, do you have any questions for me about anything before I sentence?
No, sir.
You ready?
Yes, sir.
Okay. Mr. Dennis, on 23 SR, no, I'm gonna do this numerically. On 22 SR 1380, count two, I guess he doesn't qualify for NOLA, Mr. Charles?
No, Your Honor.
That's fine, I just figured as much. And I want to put on record that we discussed it. All right, on 22 SR 1380, count two, suspended license, I'm gonna find you guilty. It's 12 months probation, 742.50 is your fine. This is from January 31st, 2022. You may work off your fine with community service work. You will need to get your Georgia driver's license back. No alcohol, illegal drugs, or hemp products should be tested for those. Fourth Amendment waiver, $50 per month supervision fee, $25 intake fee, one-time public defender payment of $50, restitution to Spalding County. Within 30 days, either provide proof that you were arrested by proof of incarceration or report to the jail to be fingerprinted and immediately released. In other words, you're not going to get booked, like put into a jumpsuit or anything like that. It's just grabbing your fingerprints. And you'll do that by appointment with the sheriff's office if you need to. 20 hours community service work at a rate of no less than 6 hours per week. And that's the sentence of the court on 22 SR 1380. All right, moving on to 23 SR 1105. Count one, suspended license. This is from March 23rd of 23. Guilty, 12 months on suspended license, 735. Count two, speeding, 77 and 55. Guilty, 12 months, 155 as your fine, for a total of 12 months of probation. Same thing, get your Georgia driver's license back. No alcohol, illegal drugs, or hemp products should be tested for that. Fourth Amendment waiver, $50 per month supervision fee. This does have an additional $25 intake fee, as well as an additional $50 public defender restitution payment. You'll also either show proof of incarceration or be fingerprinted and released within 30 days. You have 30 days from today. If you wish to appeal this decision, you have 6 months if you wish to use your habeas rights. Your third case, 23 SR 1104, is a non pros pursuant to plea negotiations, and I'm signing that document as we speak and handing it to your attorney. Any questions for you, Partways?
No, sir.
All right, if you will head out those double doors with the bailiffs, they will meet you have you meet with sentencing. Counts. All right, your attorney's making a quick copy. I'm gonna go and just do the preliminaries. Is that okay?
Yes, sir.
All right, raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, take your hand down, state your full name for me.
Dwayne Allen Counts.
All right, and Mr. Counts, you were on time for court today, is that correct?
Correct.
Did you hear the rights that were read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand the purpose?
Yes, sir.
Any questions? I'm sorry. Your attorney, who Mr. is now present, he was here in the courtroom, he just wasn't standing next to you. Passed up to me this attorney and defendant plea rights waiver. Do you recognize this document as the written version of those rights I read out earlier?
I do.
Are these your initials next to each of the lines on page 1?
They are.
Page 2?
Yes.
And is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it?
Yes.
And because, and having a chance to ask your attorney any questions you have about it?
Yes.
And because you understood everything that's on it?
Correct.
Have you had all the time that you need to speak with your attorney about all aspects of your case?
Yes, I am.
Are you satisfied with the job your attorney's done on your behalf?
I am.
Do you understand that you have the right to a jury trial?
Yes.
And that by entering this plea, there will be no trial in this case will be closed? Is that what you want to do?
Yes.
Okay. Do you have any questions for me, Mr. Council, about anything before I put it to your attorney?
No, sir.
All right. Mr. Charles, do you stipulate that there's a sufficient factual basis for you to take this plea, public indecency from August 15th of 2020 here in Spalding County?
Yes, I do.
Do you wish to enter a guilty plea to that charge?
Yes.
All right, I find that between Mr. Charles's stipulations and the defendant's request to enter a guilty plea, that there's enough for me to take the plea. I'm gonna find that he is knowingly, voluntarily, and intelligently waiving his rights and entering this plea. I reviewed the recommendation and I will follow it. Floor is yours if you want it.
No, sir, thank you very much.
Mr. Counsel, do you have any questions for me about anything before I sentence?
There was just a couple things added, like I believe on the probation and the community service.
Yes.
I thought at first it was just a fine when we first spoke with my attorney.
Yeah, the 20 hours is pretty standard for us.
I see, as I have been
Yeah,
listening.
most courts do 40 hours, we just do 20, so that's pretty standard.
Can I explain to him that he can come in here and do it?
Sure.
For probation, will tell you what to do.
Yeah, you can.
And help with the fine because I am on disability.
We have a great program for that. Communicate that to the Sentence Enforcement Office, and they will give you your options to do it other than cash. Other than restitution, we have many pathways for people to resolve their financial obligations to the court. So you're going to have options there.
Okay, thank you.
Don't panic, just ask questions, okay? Just like you just did. All right, you ready?
Yes, sir.
All right, here we go. Mr. Counsel, on 22 SR 1092, count 1, public indecency, I'm gonna find you guilty. It's 12 months probation, 445 is your fine. You may work that off with community service work if you wish. You need to show your valid license to probation. No alcohol, illegal drugs, or hemp products should be tested for those. Fourth Amendment waiver, $50 per month supervision fee, $25 one-time intake fee, $50 one-time restitution payment for your attorney. Spalding County. 20 hours community service work. Do not go anywhere near any racetracks. And that's the sentence of the court. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to use your habeas rights. Are there any questions about anything I can answer for you before we part ways?
No, sir.
All right. If you will head back that way to those double doors, and good luck. Go.
And we have one application that I request.
Okay, so this one, Middleton case?
Yes.
That was normal?
Martin?
We got
Just for,
And boy, you don't even want to know how many times I wrote 2023 because each one probably is its own offense. So,
Judge, we will see you back on the 18th, and I'll be in touch with the state, trying to work this out. And I guess it's Ms. Heffron as well that
yes.
you coordinate with.
Yeah, y'all talk to her and you just give me a call.
I just want to see what she needs in terms of trying to
But
make it
just
work.
know, sir, we'd love to have you in the program.
Yeah,
Make it as a non-starter.
Yeah, we're gonna do everything we can to figure out what we can do.
And we did transfer.
Yeah, so actually the one that's on the calendar today, they're making, they have an accountability court program down there. And we just, Kara, here we go.
She just left.
She does?
She's outside in the hallway.
If you want to talk to Kara,
No,
Kara
she's not
just
done.
transferred a case from us to Macon Accountability Court.
That's actually what I was gonna look into, frankly,
Yeah, she could
because I'd like
probably
to do this one, but if it needs to be transferred, just because, again, I don't want to set up a failure, and that would be.
Yeah, our procedure would be the same. We typically, just like normal, Kathy, do a transcript, we file it in there, we file a copy of the unsigned sentence sheet from me, signed by you, and then we transfer it. Obviously successfully complete it, we do our part, and move on. So,
Okay, I'll get in touch with them, and I'll talk to.
just freewheeling ideas, that's all.
Absolutely.
Yeah,
Thank you, Judge.
I'm fine with doing that.
Okay, that's probably what I have to do, just because I've found out this morning.
Yeah, let me know.
Okay. There's a non-procedure.
Yeah, I'll do that. We can go
All right,
ahead.
Ms. Charles, what you got next?
Oh, what's this your name? Mr. Jesse Jameson?
Williams, y'all's too.
Do I have the cross-fits up here, or is this?
Devon Williams? Is Williams? Is he yours here? You don't have one. Okay. So, do you understand what y'all? So basically, the two of y'all got arrested. Nice. You don't want to prosecute them? Okay. And won't prosecute you. So, the way that back on the 18th.
All right, Mr. Shepherd, the floor is yours.
All right, the first one is Jesse Jemison. Mr. Jemison, all right, you raise your right hand, please. Do you swear the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, can you state your name, please?
Jesse Reed Jefferson.
And Mr. Jemison, you are the defendant in the state versus Jesse Jemison, is that correct?
Yes.
And you're also the named victim in the state versus Devon Williams?
Yes.
Is that correct? All right, and my understanding is that if I were to call you to testify against Mr. Williams, that you would assert your Fifth Amendment privilege against self-incrimination and choose not to testify?
That's correct.
All right, and you're represented by an attorney in this matter?
Yes, sir.
Mr. Charles here? All right. Has Mr. Charles explained this to you?
Yes, sir.
All right, is this what you want to do?
Yes, sir.
All right, you understand that by asserting the Fifth Amendment, that the case against Mr. Williams will most likely be dismissed? You understand that case is dismissed, that any bond conditions that prevent Mr. Williams from having contact with you would also go away? All right, is that what you want to happen?
Yes.
All right, you doing this freely and voluntarily?
Yes.
Are you under the influence of any alcohol or drugs this morning?
No, sir.
Has anybody made you any promises to get you to do this?
No, sir.
Has anybody made you any threats to get you to do this?
No, sir.
That's all the questions I have for Mr.
Any
Jemison.
questions, Mr. Charles?
No, Your Honor.
All right, Ms. Jemison, step back, please.
Mr. Williams? Here you go. Will you raise your hand, please? Do you swear the testimony you're about to give before this court this morning will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, can you state your name, please?
Williams.
And Mr. Williams, you're the named defendant in the state versus Devon Williams, is that correct?
Yes, sir.
And you're also the named victim in the state versus Jesse Jemerson, is that correct? All right, and my understanding is if I were to call you to testify in the case against Mr. Jemerson, you would choose to invoke your Fifth Amendment privilege against self-incrimination, is that correct? You would choose not to testify against him
Yes, sir.
because it might incriminate you.
Yes, sir.
And you're not represented by an attorney in this.
Yes, sir.
All right, and you're doing this freely and voluntarily? Right, has anybody made any promises to get you to do this? Has anybody threatened you in any way to get you to do this? Are you under the influence of any drugs or alcohol this morning? Right, you understand that if by you choosing to assert the Fifth Amendment and not testify against Mr. Jimerson, that it's highly likely the case against Mr. Jimerson would be dismissed. You understand that if that case is dismissed, any bond conditions that limit contact between you and Mr. Jimerson would also go away.
Yes, sir.
Is that what you want to happen?
Yes, sir.
Thank you. Judges, as they are the name, this was a fight between two family members. They are the named victims, and they're also the principal witness. Without their testimony, I've been able to secure a conviction against either Mr. Jimerson or Mr. Williams.
All right, I understand, and I see the position that you're in. Will you be presenting me with an all process on this?
Yes, Judge, we'll prepare those.
All right, then I will sign those. I don't see any pathway forward for you in bringing these two cases for trial. All right, both of y'all are free to go.
I know you got a couple more pleas, but we're trying to wrap up stuff in office. Ms. Cook, you have two cases. One of them apparently represent all, well, they represent both of them. Is this not voted as a dismissal?
Wait, slow down, Mike.
So, Alyssa Cook.
Yes.
So, you found her confidence.
Yes, not a dismissal. It's that she's supposed to go over to the department and be rehabilitated if possible.
So, what do we actually do for the case until then?
Dead document.
That
would be not a problem.
That was one of the two options.
Yeah, I mean, I'm just guessing, we do get so few of these that make it this hard.
Yeah, no, I don't recall.
I've got materials on it, but I can't find them. I tried to find them. So.
Yes, Judge, it looks like there was a notice issue in this hall, and I don't believe it would be fair for her to be picked up on a bench warrant, given the circumstances of that.
Okay, well, since there was a notice issue, everybody mark your calendars, not that it's lifted.
Well, it was a notice issue.
It was a notice issue on my end.
Oh.
Yeah, I'm just saying,
Okay.
they're falling on their swords. I don't think it's fair for Ms. Hall to go to jail as a result of a clerical error in their office.
So
So
the
it would be-
answer is, the warrant is lifted, but it did count. So that way we're back to square one and we'll be good.
Yeah, it wasn't a clerk notice issue.
Okay.
I didn't want to call Kara out, but
That's right. You always do this.
Maybe.
Again, everybody can request a transcript from Kathy today of my mistakes. Okay, what else do you have, Ms. Clark?
Judge, I just have some pleas whenever you get to mine.
Let's go and do yours. Who you want me to call?
Judge, I have Christian Pitts, Richard Tucker, and Stuart Smith.
All right, let's do it in that order. Hits. At all. Okay, you're Christian Pitts?
Yes, sir.
All right, please raise your right hand. You solemnly swear or affirm the testimony about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, take your hand down and state your full name for me.
Christian Hunter Pitts.
Mr. Pitts, you are here today on 22 SR 1028. And according to my calendar, you are on time for court today, is that correct?
Yes, sir.
Did you hear the rights I read out to the courtroom and see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Your attorney has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document?
I do.
Do you recognize it as the written version of those rights I read out earlier?
Yes, sir.
Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
Is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time you needed to review it
Yes, sir.
and asking your attorney any questions you have about it?
Yes, sir.
And because you understood everything that's on it? Correct. Have you had all the time that you need to speak with your attorney about all aspects of the case?
I did.
Are you satisfied with the job your attorney's done on your behalf?
Yes, sir.
Do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial, this case will be closed? Is that what you want to do?
Yes, sir.
Do you have any questions for me about anything before I pivot to your attorney with my next set of questions?
Yes, sir.
All right, Ms. Clark, do you stipulate there's a sufficient factual basis for me to accept this reckless driving plea from driving that occurred here in Spalding County on August 7th, 2020?
Yes.
Do you wish to enter a guilty plea to that reckless driving charge?
Yes, sir.
All right, I'm gonna find between the attorney's stipulations and the defendant's request to enter the guilty plea, there's enough for me to take the plea. I'm gonna find that Mr. Pitts is knowingly, voluntarily, and intelligently waiving his rights and entering this plea. I reviewed the recommendation and I will follow it as negotiated. The floor is yours if you want it.
Judge, Mr. Pitts lives in Locust Grove, Troop County. Troop County.
Troop County.
So we're just asking if he can phone report or online report, as long as he's in compliance with probation.
Okay, that's a yes.
Thank you, Judge.
All right, anything else?
No, Your Honor.
The delay was somebody changed this form completely. It was me, and I forgot where I moved that line to. So, okay. Any questions for our sentence?
Yes, sir.
You ready?
Yes, sir.
All right, here we go. Christian Pitts, 22 SR 1028 from August 7th of 2020. Count 1, reckless driving. Guilty. 12 months probation. 1232 is your fine. You can work that off with community service work if you wish. 12 months total probation. Counts 2 and 3 are dismissed. Showing valid license to probation. Alcohol, illegal drugs, or products should be tested for those. Fourth Amendment waiver, $50 per month supervision fee, $25 intake fee. You may go to e-report after orientation. 40 hours of community service work. DUI school within 60 days. The community service work needs to be done at a rate of no less than 6 hours per week. And the DUI school needs to be turned in within 60 days. You have 30 days from today if you wish to appeal this decision, and you have 6 months from today if you wish to use your habeas rights. Any questions for me about anything before we part ways?
Yes, sir.
Judge, I will just add, I know a lot of times you want him to get their driver's license back. He's not gonna qualify to get his driver's license back until August at least. I just wanna make that note. It's possible to get it back before probation is over, but there's other things that happen, so.
Oh, there always are.
Yeah.
So what you'll do is, and sentence enforcement will show you this, they'll get you to get what's called a suspension detail report. I didn't name it, that's just the name of the document, it's an SDR. And that report tells them that you can't get it back before this certain date, and that covers it. They'll walk you through it.
All right.
Okay. All right, if you'll step through those double doors. Smith? All right, Mr. Smith,
Yes, sir.
raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, take your hand down, say your full name for me.
Stuart Smith.
All right, Mr. Smith, you're here today on 22 SR 2301. According to my calendar, I think you might have missed. Okay,
And
we're gonna,
Judge, again, that was my fault that he was not here this morning.
that's okay. I just was gonna figure out where to start in my script, so we're good. All right, I'm holding up this attorney and defendant plea rights waiver. Do you recognize this document?
Yes, sir.
Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
Is that your signature?
Yes, sir.
Did you sign and initial this document after reviewing it fully with your attorney
Yes, sir.
and reading it yourself?
Yes, sir.
And because you understand everything that's on it?
Yes, sir.
Are there any questions I can answer for you about anything on this document?
Yes, sir.
Mr. Smith, have you had all the time that you need to speak with your attorney about all aspects of your case?
Yes, sir.
Are you satisfied with the job your attorney's done on your behalf?
Yes, sir.
You have the right to a jury trial. Do you understand that?
Yes, sir.
And you are here entering this plea, which means there will be no trial and this case will be closed. Is that what you want to do?
Yes, sir.
Do you have any questions for me about anything before I pivot to your attorney with my next set of questions?
No, sir.
All right, this is not a family violence case, correct?
Correct.
I just want to put that on the record. All right, Ms. Clark, do you stipulate that there's a sufficient factual basis for me to accept this simple battery charge from June 13th of 2021?
Yes, Your Honor.
Do you wish to enter a guilty plea to this simple battery charge?
Yes, sir.
All right. I'm going to find between the attorney's stipulations, factual basis, as well as the defendant's requesting of the guilty plea that there's enough for me to take this plea. I'm going to find that Mr. Smith is knowingly, voluntarily, and intelligently waiving his rights and entering this plea. I've reviewed the recommendation and I'll follow it. The floor is yours if you want it.
Judge, we're requesting first offender in this case. This was just a bad day for Mr. Smith. He's actually done a lot of therapy and anger management following the incident that occurred on this date. And there is a provision in there about no contact except for custody order. There is an ongoing divorce, and there's a temporary agreement in place, I believe, at this time. I just didn't want this order to interfere with whatever order is going on in Superior Court. That's the idea behind that, and I think the state's on board with that as well.
Okay.
Yeah, it's our pretty usual procedure on that.
Yes. No, that's fine. All right. Have you used first offender previously in any other case?
No, sir.
And are you convicted felon?
No, sir.
Okay. Any qualifies for staff?
This is his first arrest, never had any kind of issue before.
Yeah, it did appear to be first arrest.
All right, then, first offender, here's what you need to know. First offender is a protection that you're gonna use during this. By using it, you will never, ever be able to use it again in any other case, ever, felony or misdemeanor. Do you understand?
Yes, sir.
So 20 years from now, you catch a forgery in the first degree felony, and you wanna use your first offender to keep from being a convicted felon, they're gonna say nope, because back on January 8th of 2024, you used it in front of Judge Thacker in the Spalding County State Court. Do you understand?
Yes, sir.
So is it acceptable to you that you will lose this thing forever?
Yes, sir.
Secondly, if you do not do what you're supposed to do, I will have two options at a revocation hearing. A, I'll decide whether or not you get to keep your first offender or take it away. You don't get a trial, you just get a hearing with me. Do you understand that?
Yes, sir.
And then secondly, if I do revoke your probation, I can either leave first offender in place or take it away. You understand it's two different questions at a revocation hearing versus just did you violate your probation?
Yes, sir.
And then obviously if you lose it, you both used it and lost it and it's gone. Do you understand that?
Yes, sir.
Okay. I find that he understands first offender fully. I find that he's qualified for it and I will grant the request.
Thank you, Judge.
All right, anything else?
No, Your Honor.
No, sir.
Okay, let's go. Stuart Smith, 22 SR 2301 from June 13th of 2021. Count one, simple battery. I'll say it again, this is not a family violence case. Guilty, 12 months, 735 is your fine. This entire case is granted under first offender. You may work off your fine with community service work. That'll be 12 months of probation. Show your valid license to probation. No alcohol, illegal drugs, or hemp products. You'll be tested for those. Fourth Amendment waiver, $50 per month supervision fee. $25 intake fee. No contact with Taylor Smith, and I modified the language just a little bit, and it says, except as needed for custody visitation per court order. So I don't want you deciding what you need for custody visitation, but you may act according to any other court order that directs you otherwise. Does that make sense?
Yes, sir.
All right. And you are to have access to no firearms or ammunition. All right. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to use your habeas rights. If you have any questions for me about anything, before you and I part ways?
No, sir.
All right. Go and successfully complete this thing so that you can get this cleaned up off your record. Okay?
Thank you.
All right. If you walk out that way, out those double doors, you can smart. All right. Your last case is Tucker. All right. Raise your right hand for me. You solemnly swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right. Take your hand down. State your full name for me.
Richard Lee Tucker.
All right. Mr. Tucker, you are on time for court today. Is that correct?
Yes, sir.
Did you hear the rights are read out in the courtroom and see the PowerPoint that I put up on the wall?
Yes, sir, I did.
And did you understand those rights?
Yes, sir.
Your attorney has passed out to me this attorney and defendant plea rights waiver. Do you recognize this document I'm holding up?
Yes, sir.
And do you recognize it as the written version of those rights I read out earlier?
Yes, sir, I do.
Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2,
Yes, sir.
is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it,
Yes, sir, I did.
to ask your attorney any questions that you have about it,
Yes, sir.
and because you understood everything that's on it?
Yes, sir.
Have you had all the time that you need to speak with your attorney about all aspects of your case?
Yes, sir, I have.
Are you satisfied with the job your attorney's done on your behalf?
Yes, sir, I am.
Do you understand that you have the right to a jury trial,
Yes, sir.
and that by entering this plea, there will be no trial and this case will be closed? Is that what you want to
That
do?
is correct.
Any questions for me about anything before I pivot to your attorney with my next set of questions?
No, sir.
All right, Ms. Clark, do you stipulate there's factual basis for this disorderly conduct here in Spalding County from May 17th of 2020?
Yes, sir.
And Mr. Tucker, do you wish to enter a guilty plea to this disorderly conduct charge?
Yes, sir.
I'm going to find that between the attorney's stipulations, the factual basis, combined with the defendant's request to enter a guilty plea, that there's enough for me to take the plea. I'm going to find that Mr. Tucker's knowingly, voluntarily, and intelligently waiving his rights in entering this plea. Review the recommendation. I'll follow it as it's been negotiated. The floor is yours if you want it.
Judge, I just ask that you accept the recommendation.
Happy to. Any questions, Mr. Tucker?
No, sir.
All right, you ready?
Yes, sir.
Here we go. Richard Tucker, 22 SR 1256, from May 17th of 2020, count 1, disorderly conduct, guilty, 12 months, 590 is your fine. You may work off your 5 months community service work if you wish, 12 months of probation, show your valid license to probation, no alcohol, illegal drugs, or hemp products should be tested for those, Fourth Amendment waiver, $50 per month supervision fee, $25 intake fee. And this case may close the moment 3 months have passed, no violations have occurred, and all conditions have been met. There are no additional special conditions. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to appeal these rights. All right, any questions about anything, sir, before we part ways?
No, sir.
Anything else?
No, Your Honor.
It's your last case, right?
Yes.
All right, then if you'll go with Mr. Williams, and Ms. Clark, it's always good to see you.
You too, Judge. See you next time.
Thank you, too.
You still have 4 on the calendar. Nathan Williams is one, Michael Wilson, Marlon Moultrie, and Sean Tyler Morris. They should all the paperwork should be up there with you, Judge.
How about this? You just call your clients up and I'll find it.
All right. Tyler Morris, Sean Tyler.
All right. All right, please raise your right hand for me. You solemnly swear or affirm the testimony about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, take your hand down, say your full name for me.
Sean Tyler Morris.
Mr. Morris, you are here today on 22 SR 1292. And according to my calendar, you are on time for court today, is that correct?
Yes, sir.
We have 2 cases.
Yes, Your Honor. It's 1291 is the case that there'll be no process.
This one. All right, so. That'll work. Mr. Morris, you heard the rights I read out in the courtroom and you saw the PowerPoint on the wall.
Yes, sir.
Do you understand those rights?
Yes, sir.
Your attorney's passed up to me this attorney and defendant plea rights waiver. Do you recognize this document?
Yes, sir.
Do you recognize it as the written version of those rights?
Yes, sir.
Are these your initials next to each of the lines on page 1?
Yes, sir, they are.
Page 2?
Yes, sir.
Is that your signature?
Yes, sir.
Did you sign and initial this document after having all the time you needed to review it
Yes, sir.
and to ask your attorney any questions you have about it,
Yes, sir.
and because you understood everything that's on it?
Yes, sir.
All right. Hey, James, 2 guys talking in the back. You need to step out.
Let's go, please. 7 hours.
Y'all can have your conversation out in the hallway. Okay, Mr. Morris, back on record. Okay, have you had all the time that you need to speak with your attorney about all aspects of both of your cases?
Yes, sir.
Are you satisfied with the job he's done on your behalf?
Yes, sir.
You understand that you have the right to a jury trial,
Yes, sir.
and that by entering this plea, there will be no trial, this case will be closed. Is that what you want to do?
Yes, sir.
Um, do you understand you're giving up the right to a jury trial?
Yes, sir.
And by entering this plea, that's what's gonna happen, is that what you want to do?
Yes, sir.
Do you have any questions for me about anything before I get it to your attorney with my next set of questions?
No, Judge.
Mr. Hudson, do you stipulate there's a sufficient factual basis for this theft by deception charge here in Spalding County on September 20th, 2021?
I do, Your Honor.
You wish to enter a guilty plea to that theft by deception charge?
Yes, sir.
All right. I'm gonna find between the attorney's stipulations, the factual basis combined with the defendant's request to enter the plea, there's enough for me to take the plea. I'm gonna find that Mr. Morris is knowingly, voluntarily, and intelligently waiving his rights in entering this plea. I'll review the recommendation and I'll follow it as recommended. Floor is yours if you want it,
No, Your Honor, we were just gonna ask for you to accept the recommendation.
which I'm happy to. All right, Sean Morris, any questions before I sentence?
No, sir.
All right, you ready?
Yes, sir.
All right, Sean Morris, 22 SR 1292, count one, theft by deception, guilty. It's 12 months, it's 590. You wore a tie today, though. And that tie is gotta be worth something, so
Thank you, Judge.
reduce your fine by $100 based on that, which
Thank
means
you,
you're
Judge.
445. You can work that off with community service work. Show your valid license to probation, no alcohol, illegal drugs, and hemp products should be tested for those. $50 per month supervision fee, $25 one-time intake fee. $500 in restitution to Rita's Pawn Shop. You will make that payment within 180 days directly to the clerk as a one-time payment. And you must provide that receipt to Citizen Enforcement within 180 days. You have no contact whatsoever with Marilyn Piper or John Gilstrap. That's the sentence of the court. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you want to use your habeas rights. Any questions for me about anything before we part ways?
Judge, I have one quick thing.
Sure.
He brought up to my attention that his license expired yesterday.
It was
That's
my
the reason
birthday.
why he has a licensed driver with him today.
Ah.
He's just not gonna be able to show you a valid license.
But I
until
do
he
have
gets
an
it.
appointment for tomorrow morning to get it
That
done.
sounds like a fine.
I'm sorry.
I know he was gonna be worried about it.
I'm
if
a
I
big
didn't
fan
say
of
so.
plans.
Yes.
Okay, your second case, 22 SR 1291, is dismissed pursuant to plea. It's not process pursuant to plea negotiation.
Yes, Your Honor.
That goes down.
And the restitution for that second case was applied to the,
Oh, that's what it came out of the second case. That makes sense. So, okay, if you'll step out, let's start with that.
Thank you,
but there's
Judge.
restitution owed on both cases, I just combined them in the first.
Oh, they both went to Rita's Pawn Shop?
Yes.
Oh, well, that's, okay. That makes perfect sense. All right, that'll work. All right, call your,
Michael Wilson, Your Honor.
all right, Mr. Wilson, I'm gonna place you under oath. Are you ready? Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, state your full name for me.
Michael George Wilson.
All right. Mr. Wilson, you are here on 22 SR 780. And according to my calendar, you are on time for court today, is that correct?
Yes, sir.
Did you hear the rights read out to the courtroom, and did you see the PowerPoint that put up on the wall?
Yes, sir.
Did you understand those rights?
Yes.
I'm holding up this attorney and defendant plea rights waiver. Do you recognize this document?
Yes.
Do you recognize that it's the written version of those rights I read out earlier?
Yes.
Are these your initials next to each of the lines on page 1,
Yes.
page 2?
Yes.
Is this your signature?
Yes.
Did you sign and initial this document after having all the time that you needed to review it?
Yes.
And to ask your attorney any questions that you have about it?
Yes.
And because you understood everything that's on it?
Yes, sir.
Have you had all the time that you need to speak with your attorney about all aspects of your case?
Yes, sir.
Are you satisfied with the job your attorney's done on your behalf?
Yes, sir.
You understand that you have the right to a jury trial,
Yes, sir.
and that by entering this plea, there will be no trial, and this case will be closed. Is that what you want to do?
Yes, sir.
All right, so, Mr. Wilson, do you have any questions for me about anything before I hit it to your attorney with my next set of questions?
No, sir.
Mr. Lee, do you stipulate that there's a sufficient factual basis for me to accept this plea for driving that occurred here in Spalding County on July 4th of 2020 and resulted in this count of DUI less safe?
Yes.
You wish to enter a guilty plea to DUI less safe, Mr. Wilson?
Yes, sir.
All right, I'm gonna find with your admission of, with the attorney's stipulations, factual basis combined with the defendant's request to enter a guilty plea, there's enough for me to take the plea. We'll find that you are knowingly, voluntarily, and intelligently waiving your rights and entering this plea. I reviewed the recommendation and I will follow it as negotiated. Okay. Floor is yours if you want it.
Yes, just a couple things I wanted to address. I think probation and I know will work with Mr. Wilson. And obviously, he's got some limited mobility right now, and there's some issues where we were asking for some milder form, I guess, of the community service that they would work with him about that. And I've told him to talk with them and let them know that. And obviously, if there's any problems, he can let me know. As far as a limited permit, Your Honor may have addressed that earlier. I was to address that as well.
Yeah, so I'm not gonna pick up his license today. I'm gonna let him work that out with DDS later. We'll report it within 48 hours.
Okay.
So as long as the address on your license is correct, you will receive a notice in the mail, usually about a week and a half out, and then you'll need to follow those instructions.
Okay, I thought that's what you were talking about while you came in on the table.
We did that during COVID and we just never pivoted back. Frankly, it's a lot easier on me. And I'm being a little bit selfish about it.
I understand. Is there anything else?
Okay, anything else?
I think that's all.
All right, Mr. Wilson, any questions for us, tenants?
No, sir.
You ready?
Yes, sir.
All right, Michael Wilson, 22 SR 780 from July 4th of 2020, count 1 DUI less safe, finds you guilty, 12 months probation. Your fine is $1,603, but you wore a coat and button down court today. I always want folks to dress up for religious services, so $1,486.50 is your new fine, is reduced by $100 base fine. 12 months probation, counts 3 and 4 are dismissed. 1 day in jail, credit for time served on that. You don't need to go back. Get your valid license back. No alcohol, illegal drugs, or hemp products should be tested for those. Fourth Amendment waiver, $50 per month supervision fee, $25 intake fee. You may go to e-report after completion of all terms. 40 hours community service work and no less than 6 hours per week. Substance abuse evaluation within 90 days, DUI school within 60 days. You have 30 days from today if you wish to appeal this decision. You have 6 months from today if you wish to use your habeas rights. Do you have any questions for me about anything before we call this? Mr. Lee, anything else?
Nothing further.
All right, well, that takes care of Mr. Wilson's case. Mr. Wilson, if you'll step that way with Ms. Martin. What else you got there?
Marlon Moultrie, Your Honor, he's actually on your January 9th calendar.
Okay, come on up. Please raise your right hand for me. You solemnly swear or affirm the testimony about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
There it is. All right. All right, state your full name for me.
Marlon Price Moultrie.
Mr. Moultrie, you are here today, and as I said earlier, you appear on the January 9th calendar, which is a continuation of this calendar. You are on page 7. Yeah, top of page 7. Okay, but you are on time for court today, is that correct? Did you hear the rights I read out to the courtroom, and did you understand them?
Yes.
Mr. Moultrie, your attorney has passed up to me as attorney and defendant pre-rights waiver. Do you recognize this document?
Yes, sir.
Do you recognize as the written version of those rights I read out earlier?
Yes, sir.
Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
Is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time you needed to review it
Yes, sir.
and have a chance to ask your attorney any questions you have about it?
Yes, sir.
And because you understood anything that's on it, everything that's on it?
Yes, sir.
Mr. Moultrie, have you had all the time that you need to speak with your attorney about all aspects of your case?
Yes, sir.
Are you satisfied with the job he's done on your behalf?
Yes, sir.
Do you understand that you have the right to a jury trial?
Yes, sir.
and that by entering this plea, there will be no trial and this case will be closed. Is that what you want to do?
Yes.
All right. Do you have any questions for me about anything before I pivot to your attorney?
Yes.
Mr. Lee, do you stipulate there's a factual basis for this harassing phone calls charge from October 19th of 2022 here in Spalding County?
Yes.
And do you wish to enter a guilty plea to this harassing phone calls charge?
Yes.
Your Honor, it is. We are requesting this under first offender. I'm sorry, I didn't.
No, that's okay. Have you used first offender before on any previous case?
No, sir.
Are you a felon or convicted felon?
No, sir.
And do you understand that if you use first offender here, you will never be able to use it again in any class of case or court ever under any circumstances?
Yes, sir.
And if you do not successfully complete your probation terms, I have the right to both revoke your probation and take away your first offender at a hearing. You do not get a jury trial. Do you understand that?
Yes.
And so if you don't do what you're supposed to do, you're both going to lose your first offender and I'm going to revoke your probation and you'll have used it, lost it, and gained no benefit. Do you understand that?
Yes.
Okay, I'm sure that's not what's going to happen, but it's my job to say awkward things out loud.
Yes.
Okay. All right, then I find that he qualified for it and I'll grant that request.
Thank you, Your Honor.
Well, I don't normally do non-report with it. I can do e-report. I want to, like we always, if I'm going to do first offender, I usually have them having touch points to make sure they're, he's set to go to non-report, I could do e-report. If they're going to get a clean history, I want to be able to know that they're doing what they're supposed to do.
Right. Yep. There were some circumstances, I guess, the reason that we talked about, because ordinarily I don't think Mr. Shepherd would have. There were some circumstances we talked
Yeah,
about.
I'll agree to it, Judge.
Okay. All right, so
Trying to
so
think
you're
how-
okay with it staying as it is to non-report?
Yeah, I mean, as long as the stay-away's in place.
And we do know that.
Okay. So, and again, I just normally, if I'm gonna give somebody a clean history, I want to have,
I understand,
I
yeah.
want to have sense of enforcement having had a good eye on it. So.
This one's got some moving parts, Judge.
Yeah, I'm catching that. It's okay. So, all right. Well, then it's gonna stay.
Thank you, Judge.
All right. Anything else?
Anything else? Nothing further.
All right, Mr. Moultrie, any questions?
No, sir.
You ready for me to sentence?
Yes, sir.
All right. Marlon Moultrie on 23 SR 0435 from October 19th of 2022. Count 1, harassing phone calls. I'm going to grant your first offender request. I'm going to find you guilty, but I'm going to withhold the finding of guilt on the first offender status. 12 months probation, $590 is your fine. It's 12 months probation. Count 2 is dismissed. Show your valid license for probation. No alcohol, illegal drugs, or hemp products should be tested for those. Fourth Amendment waiver, $50 per month supervision fee, $25 intake fee. You may go to non-report. Upon completion of all terms. Is it, it's just as soon as he completes everything, correct?
Yes.
Okay, that's fine. And then no contact whatsoever with Sarah Turner. And as I told the gentleman who had contact with the person last time, on last Thursday when I was here, right before I revoked 12 months of his probation, don't have any contact with her, or you will know very quickly that I'm still here. And I will very easily, happily, and without hesitation revoke the balance of your probation. Do you understand that?
Yes, sir.
Okay. No contact means no contact. I don't know how to communicate that any clearer. It's not your fault. It's just plenty of folks ahead decided to go ahead and try to have contact. So you have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to use your habeas rights. All right, anything else?
Nothing further.
All right, if we'll go with Mr. Williams, out those double doors. Thank you, Mr. Moore. All right, what else you got?
Nathan Williams, John.
Okay, Mr. Williams, raise your right hand. You solemnly swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, Mr. Williams, state your full name for me.
Nathan Lee Williams?
Mr. Williams, you're here today on 22 SR 1703,
Yes.
and my understanding is you were on time for court today, is that correct?
Yes, sir.
Did you hear the rights read out to the courtroom and see the PowerPoint that I put up on the wall?
Yes, sir.
And you understand all of those rights?
Yes, sir.
I'm holding up this attorney and defendant play rights waiver. Do you recognize this document?
I do.
Do you recognize it as the written version of those rights I read out earlier?
Yes, sir.
Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
And is that your signature?
It is.
Did you sign it in addition to this document after having all the time you needed to review it
Yes, sir.
and to ask your attorney any questions you have about it,
Yes, sir.
and because you understood everything that's on it?
Correct. Yes, sir.
If you had all the time that you need to speak with your attorney about all aspects of your case,
Yes, sir.
are you satisfied with the job he's done on your behalf?
I am.
You understand that you have the right to a jury trial.
I do.
And by entering this plea, which calendar is he on?
He should have been on today's.
He's on the desk.
Yeah, I think he's on Wednesday.
Oh, I'm sorry.
They brought all theirs in. Mr. Moulton's
Yeah,
on
I appreciate
tomorrow.
that very much. This is the moment where I lose them, but no, y'all did exactly what I was supposed to do. Okay, there it is, thank you. All right, you're on Wednesday's calendar on page 4, just for the almost mark the calendar. Okay, so, Mr. Williams, have you had all the time you need to speak with your attorney about all aspects of your case?
Yes, sir.
You satisfied with the job he's done?
I am.
You understand you're giving up the right to a jury trial?
I do.
Mr. Hudson, do you stipulate there's a sufficient factual basis for me to take this DUI plea from June 30th of 2021 here in Spalding County?
I do, Your Honor.
Do you wish to enter a guilty plea to that charge?
Yes, sir.
All right, I'll find between the attorney's stipulations, the facts, factual basis combined with Mr. Williams' request to enter a guilty plea, there's enough for me to take this plea. I'm gonna find that he's knowingly, voluntarily, and intelligently waiving his rights and entering the plea. I'll give the recommendation, and I'll follow it as negotiated. Mr. Hutchinson, the floor is yours.
Your Honor, the only thing that I briefly wanted to mention is that Nathan, he lives in Hurd County, Your Honor, which is the reason why Patrick okayed e-reporting after the orientation. He understands he's got some conditions that he's gonna have to live up to. But if you would honor that e-report, I would appreciate it.
Oh, yeah.
Additionally, he, as far as his license is concerned, Your Honor, this is probably gonna be one of those that's kind of hinky because he has since moved and he reported the change of his driver's license, the address to DDS. Hopefully they got it, but like I say, when I rely upon DDS to get something right, that's usually when bad things happen. So anyway, long story short, I was gonna ask if I could get a certified copy of the disposition so he could have it in hand, so he could go ahead and go to the Department of Driver Services. Erica said she'd do that for me, but
yes.
I don't know if that will sidestep the landmine that undoubtedly will come our way, but
Yeah.
anyway, that's, just wanted to mention that on the record.
I'm with you on that. Sorry I didn't talk over you, but I get where you're going on that, and yes, I think a certified copy is a great idea. You can also set up the DDS app for yourself,
Okay.
and it'll tell you exactly what they think your address is. So, having a DDS app is a really good idea.
All right.
Okay. Anything else?
No.
Any questions?
No, sir.
You ready for me to sentence?
Yes, sir.
All right, here we go. Nathan Williams, 22 SR 1703 from June 30th of 2021. Count 1, DUI. Find you guilty. This 12 months probation. I sense a pattern here that Virgil Brown's office told their people to wear ties and dress up for court because I'm knocking another $100 off of another case.
Thank
So
you,
that
Judge.
brings the base 100 down, which brings the total to 1486.50. All right, 12 months probation, 1 day in jail. That's served in full. Get your Georgia driver's license back, or obviously provide a suspension detail report showing why you can't. No alcohol, illegal drugs, or hemp products should be tested for those. Fourth Amendment waiver, $50 per month supervision fee, $25 intake fee. You may go to e-report after orientation because I lived here my whole life. I took a job in Hurd County for a little while. I drove it for 6 months until my wife said, no more. And so I'm well aware of that drive.
Right.
So 40 hours community service work, substance at 6 hours per week, substance abuse evaluation within 90 days, DUI school within 60 days. For proof of completion. If 30 days from today, if you wish to appeal this decision, you have 6 months from today if you want to use your habeas rights. Okay. Anything else, Mr. Hudson?
No, Your Honor. We appreciate the court.
All right. If we go with Mr. Clinton, that was double dose. What else y'all have?
I believe we caught up, and there was dead dockets, non-process, stuff like that. Pemberton was one of them.
Pemberton's on the bottom of page 8. Did you for today?
I'm not certain. Yeah, that's it. I got a mango.
Yeah. So, yeah,
Oh,
Pemberton,
there it is. I see it.
the dead docket, and Mangum was the plea
Yeah,
bar.
Dexter.
Okay, I'm gonna do this to you to get that.
Yes, sir.
Okay, Pemberton, Kathy was a dead docket, Mangum, 971 is. Y'all, I'm not doing a good job keeping up with my calendar stuff. All right, Bradley. I have 3 pleas left. All right, everybody, let's come back to order. Are you Eddie Brownlee?
I am.
All right, if you'll please raise your right hand for me. You solemnly swear or affirm the testimony about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
All right, take your hand down and state your full name for me.
Azalea Brown.
All right, Ms. Brownlee, you are here today on 22 SR 1177, and it appears you were on time for court today, is that correct?
Yes, sir.
Did you hear the right to run out to the courtroom and see the PowerPoint that's put on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
You have passed up to me this self-represented defendant plea rights waiver. Do you recognize this document?
Yes, sir.
Are those your, do you recognize that it's the written version of those rights I read out earlier?
Yes.
Are those your initials next to each of the lines on page 1,
Yes, sir.
page 2?
Yes, sir.
Is that your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it?
Yes, sir.
And because you understood everything that's on it?
Yes, sir.
Ms. Brownlee, you understand that you have the right to have an attorney represent you,
Yes, sir.
and you're here representing yourself?
Yes, sir.
Is that what you want to do on your case?
Yes, sir.
You understand that you have the right to a jury trial,
Yes, sir.
and that by entering this plea, you're giving up that right to a jury trial. Is that what you want to do?
Yes, sir.
Ms. Brownlee, you are charged with 1 count of obstruction of a law enforcement officer, and that you did obstruct law enforcement officers on September 9th, 2020 by failing to obey lawful commands. Did you do that?
No.
All right, let me take a look at this now. Okay, what I'm doing is I'm going to pull the accusation and I'm going to read the language exactly as it is and see if that moves it forward. Okay, so the accusation for count 1 specifically reads that you did here in Spalding County on or about the 9th day of September 2020 unlawfully, knowingly, and willfully obstruct Investigator Markevius Johnson, a law enforcement officer in the lawful discharge of official duties by refusing to comply with lawful commands. Did you do that?
No.
Okay. So I have 2 options at this point, and you're in charge. You ready?
Yes, sir.
You tell me. One option is I can stop this plea and I can move you over to the trial calendar, and we can set you up for a jury trial or bench trial, whatever you prefer. The second option is you can ask me to continue this, but I'll pivot over to what's called a best interest plea. A best interest plea is where you don't admit that you did the thing underneath the case, but you do say to me that you've considered all your options, you understand them fully, and that you believe that accepting these terms is in your best interest because of the potential of being convicted at trial. And so that's called a best interest plea. So you're in charge, you're in the captain's seat here, and you're going to tell me what you want to do with your case. Do you want me to move you towards a trial posture, or do you want me to continue this plea with the best interest where you don't have to admit to the underlying facts?
Continue.
Okay, so I'm going to initial up here where it says that this is a best interest plea now. And so I'm going to withdraw my question of did you do it, and I'm going to change that question to, after considering all of your options, given the charge of obstruction regarding Investigator Markevius Johnson, do you believe that it is in your best interest to enter this plea and close this case?
Yes.
Okay. I'm going to find that the best interest plea is proper and I'm going to grant it. I'm going to find that you're knowingly, voluntarily, and intelligently waiving your rights in entering this plea. I reviewed the recommendation and I'll follow it. Any questions before I sentence? Okay. Isaiah Brownlee on 22 SR 1177 from September 9th, 2020. Obstruction, guilty, 12 months, 870. Shadeville license probation, Count 2 is dismissed. You can work off your phone with community service work. $50 per month supervision fee, $25 intake fee, and your case will terminate the moment you've satisfied your obligation to the court. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to use your habeas rights. All right, any questions from me about anything before a sentence?
No, sir.
Before we cover it, sorry. Okay, then I'm gonna pass you off to Mr. Clint. He's gonna walk you back to sentence enforcement and they'll take it from there. Thank you.
Thank you.
DeMarco? Del Marco, sorry. Oh, and I knocked $100 off because you wore a jacket. No. Okay, I'm sure I didn't say that, but I did it. You'll see it on the paperwork. Okay. Raise your right hand. You solemnly swear or affirm the testimony about the truth in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, take your hand down and state your full name for me.
Carl John DeMarco.
All right, Mr. DeMarco, you're here on 23 SR 0684. And according to my calendar, you were on time for court today. Is that correct?
Yes, sir.
Mr. DeMarco, did you hear the rights are read out to the courtroom? Did you see the PowerPoint that put up on the wall?
I did.
Did you understand those rights?
Yes, sir, I did.
Any questions I can answer for you about those rights?
No.
You have passed up to me this self-represented defendant clear rights waiver. Do you recognize this document?
Yes, sir.
You recognize it as the written version of the rights I read out earlier?
I do.
Are those your initials?
They are.
Next to each of the lines on page 1, page 2?
Yes, sir.
Is that your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it?
I did.
And because you understood everything that's on it?
Yes, sir.
He's not on the calendar, is that right, Mike?
That's
This is the walk-in?
yes, sir.
Okay. So it's 23 SR 1684. I was trying to pull up his accusations. Okay. Do you understand that you have the right to have an attorney represent you?
I do.
And you're here representing yourself?
Yes, sir.
Is that what you want to do?
Yes, sir.
Do you understand that you have the right to a jury trial?
I do.
And that by entering this plea, there will be no trial and this case will be closed? Is that what you want to do?
Yes, sir, it is.
All right, you are charged with one count of reckless conduct in that you did here in Spalding County back on February 18th, 2022, unlawfully endanger the public safety by disregarding a substantial and unjustifiable risk by firing a handgun near a public roadway which endangered the safety of persons using that roadway. This was a gross deviation from the standard of care that a reasonable person would exercise in this situation. Did you do that?
Yes, sir, I did.
All right, I find that with your admission of guilt, there's enough for me to take your plea. I'm gonna find that you're knowingly, voluntarily, and intelligently waiving your rights and entering this plea. I reviewed the recommendation and I will follow it. Do you have any questions for me about anything before I sentence?
I think it would be the first offender, so.
I don't mind granting that. I just want to make certain that you understand that if you use it here today, you will never again be able to use a first offender on any other charge ever for the rest of your days.
I'll never get in trouble like this again. Yes, sir, I understand.
That's fine. It's just my job to say that.
I understand that.
And that means that if you catch a felony next year and you reach for first offender like so many felons do to keep from being a convicted felon, it will not be there. Do
This
you
is my
understand?
first time in court, my last, yes, sir. I
That sounds
understand.
fine. Okay. If you do what you're supposed to do, then at the completion of this case, your case will be closed with no finding of guilt. If you do not do what you're supposed to do, we'll have a hearing where you stand there and I sit here. No jury will be present, and I will decide whether to revoke your probation and whether or not to take away your first offender. Do you understand?
Yes, sir.
And so if you don't do what you're supposed to do, you're going to lose your first offender, and you've used it, and you've lost it, and you gain no benefit. Do you understand that?
I do.
Okay. I'm going to find that you and I have thoroughly talked about it. You haven't used it previously because this is your first time ever being in court. You're not a convicted felon. You qualify, and you would like to use it. Is that correct?
Yes, sir.
Okay. Anything else?
No, sir.
Okay, here we go. Carl Del Marco on 23 SR 684 from February 18th, 2022. Reckless conduct. I'm finding you guilty, but I'm granting your first offender and withhold the final finding of guilt. It's 12 months probation. $482.50 is your fine. 12 months total probation. Show your valid license to probation. No alcohol, illegal drugs, or hemp products. You'll be tested for those. don't know that fine amount. No, that's okay. Reduce your fine to $449.50 for wearing a tie. Okay. No alcohol, no illegal drugs, no hemp products. You'll be tested for those. $50 per month supervision fee, $25 intake fee, one time. You may go to non-report and only if you satisfied your obligations to the court. Actually, it's because it's this. I normally don't do non-report. What I am going to do is pivot you over to e-report, so that you don't have to go in. You just have to touch base to make certain that you're doing what you're. When I do first offender, I got to keep a little closer eye on you. And so I'm actually going to remove the non-report, and I'm going to move you over to e-report, because at the end of this, you're going to get a clean record, and I need to know that you've earned it.
Yes, sir.
Okay, but that'll take care of it. Okay. All right, that's it. Good luck to you. I'm very confident I won't see you again, other than just around town. Okay?
Thank you very much.
Thank you. All right, last case. Mays. All right, is there anybody else waiting to have their case addressed? All right, what's your name? Mays? What's your name?
She wanted a trial.
Oh, okay.
Both of these are tried.
Okay, I'll talk to you. And what's your name?
Colburn, Wayne.
Also a trial.
Okay.
Okay.
Okay. That's fine, I'll talk to both. All right, raise your right hand for me. You solemnly swear or affirm the testimony about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, state your full name for me.
Cedric Mays.
All right, Mr. Mays, you are here on 22 SR 2314. You're going late today because you were talking loudly in the back of the courtroom.
That
No, that wasn't me.
Oh, that wasn't you?
No,
That
sir.
was him.
Oh, well, great.
No, sir.
Okay, well, sorry about that. All right, Mr. Mays, you're here on 22 SR 2314 from October 2nd, 2022, and you were on time for court today, is that correct?
Yes, sir.
Did you hear the rights you read out to the courtroom, and did you see the PowerPoint that's put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Mr. Mays, do you understand, you have passed up to me this self-represented defendant rights paper. Do you recognize this document?
Yeah, yes, sir.
Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
Is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it,
Yes, sir.
and because you understood everything that's on it?
Yes, sir.
You understand that you have the right to have an attorney represent you,
Yes, sir.
and you're here representing yourself?
Yes, sir.
Is that what you want to do?
Yes, sir.
Mr. Mays, do you understand that you have the right to a jury trial on this case?
Yes, sir.
And that by entering this plea, there will be no trial and this case will be closed? Is that what you want to do?
Yes, sir.
Mr. Mays, did you here in Spalding County back on October 2nd of 2022 operate your motor vehicle while you had an alcohol concentration in your blood of 0.08 grams or more within 3 hours of your driving being concluded? Did you do that?
Yes, sir.
Did you also follow another vehicle too closely for safety, given the conditions of the road?
Yes, sir.
That was yes?
Yes, sir.
Okay. I'm going to find with your admission of guilt as to counts 1 and 2 that there's enough for me to take your plea. I'm going to find that you're knowingly, voluntarily, and intelligently waiving your rights in entering this plea. I reviewed the recommendation and I'll follow it according to the recommendation. Do you have any questions for me before I sentence?
No, sir.
All right, you ready?
Yes, sir.
All right, sorry, Gary. All right, count 1, DUI, DUI per se, guilty, 12 months, $866.50 is your fine. Count 2, following too closely, guilty, 12 months consecutive, $155 is your fine. That's 24 total months of probation. You're to do 10 days in jail. That'll be served in 48-hour increments on the weekends, and I'm going to have that start on.
I'll ask.
When do you want it to start? I can.
I would like to get a little time, sir, because I said I worked down here at Bridgestone Bank.
That's okay. Just tell me what you need. I don't need the backstory. I just need you
I'm
to tell
just
me what you
trying
need.
to give me a little time to get everything together, so I could,
What's a little time?
maybe about a week or two.
Okay, that's fine.
Yes, sir.
I'm just going to give you what you want, but
Yes.
then you got to do what you're asked for.
Yes, sir.
So,
Yeah.
okay, then let's see. Today's the 8th. So how about I push this over to your weekends will start on Friday the 26th?
Yeah, that works.
You get weekends off?
Well, so far they've been there. We just been doing Monday through Friday, so I'm gonna take my paperwork down the other day and hopefully.
Well, we're gonna move it around your schedule.
Yes,
So,
yes, sir. Yeah.
okay, well then I'm just gonna put that you must start your weekends before January 31st. How about that?
Okay.
So, and you can work out when those, I don't care what the 48-hour block is, and I don't want you to lose your job.
Yeah.
So, but you gotta do them consecutive. Okay? All right. Anything else before I jump back in?
No, sir.
All right, show you valid license, probation, no alcohol, illegal drugs, or hemp products. We tested for those. Pay a monthly $50 supervision fee, $25 intake fee, 40 hours community service work at no less than 6 hours per week, substance abuse evaluation, DUI school, and that's the sentence of the court. You have 30 days from today if you wish to appeal this decision. You have 6 months from today if you want to use your habeas rights. All right, any questions?
Yes, sir.
All right, if you will walk with Mr. Clinton out there. All right, and let's talk to our trial folks. Come on up.
Okay.
I sent you
What was your name again?
Wayman Colbert.
This was the walk-in. I mean, not the walk-in, the add-on. Battery, family balance, 22 SR 1186. Mr. Colbert, do you wish for me to put you down for a bench trial or a jury trial?
Jury.
Are you wishing to represent yourself at this case, during this case?
Yes.
Okay. Is it just the one charge of battery? Family
Yes.
balance? Okay. So, raise your right hand for me. You solemnly swear or affirm the testimony about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, take your hand down, say your full name for me.
Wayman Bars Colbert.
Mr. Colbert, you're here on 22 SR 1186, and according to my calendar, you are on time for court. Is that
Yes.
correct? Mr. Colbert, you did you hear the rights I read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes.
And did you understand those rights?
Yes.
You have the right to have an attorney represent you, and I'm understanding you wish to represent yourself. Is that correct?
Yes.
All right. If you will see this document, it says, you see where it says, "I am the defendant in this matter."
Yes.
I knowingly, freely, and voluntarily waive formal arraignment, as well as the right to counsel at my jury trial. I plead not guilty to the charges below and demand a jury trial. Is that correct?
Yes.
All right, go ahead and sign that. And you will see I attached a copy of your accusation to the back of that document. And that's the question the jury will be answering. You only have one charge.
Okay.
I will see you back here at 9 a.m. sharp on January 22nd. Do not be late. I'll have no tolerance for that. Be early. And you need to be ready to try your case. It will happen sometime during that week. You will need to stay until we reach your case, okay?
Yes, sir.
All right, any questions before we part ways?
No, sir.
All right, you're free to go. I'll see you back here as directions I've just given you. Okay, thank you. You can go back that way. And come on up.
Oh, no.
Oh, sorry, I was saying man, come on up. That's okay. What was your name again?
Brown.
Brown. Okay, Brown. There it is. All right, Ms. Brown, raise your right hand for me. You solemnly swear or affirm the testimony you're about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, take your hand down, say your full name for me.
Give me the Archie Brown.
Area on 22 SR 1189. Ms. Brown, you have, looks like about two cases, two charges. Yeah, you have one count of battery, family violence, and then one count of
Speaking.
battery, physical harm.
Stand there.
That's okay, I printed documents. That's all right. Do you wish to have a jury trial or a bench trial?
Jury trial.
Just tells me which paperwork to fill out.
Yes, sir.
Are you wishing to represent yourself?
No, sir.
Are you currently represented by counsel?
No, sir.
All right, well, that puts us in a bind. You either represent yourself or have an attorney, and you have neither. So what is it you want me to do?
I'm not allowed to court for a lawyer.
You were, we went over that at your arraignment date, that you had the right to apply, and I asked you to apply in the courtroom on that day. Why did you not apply in the courtroom on that day? That would have been on July 31st of 2023.
Mhm.
Can you answer that question for me?
I'm not. Just. I don't have an answer, sir.
Okay, because my position on it is that I gave you the opportunity in the courtroom here with the public defenders present. And I asked if you would fill out the application before you left. I'm pulling my notes from the case. My notes from July 31st show that you asked for a conference, and when that conference was not successful, you asked for a jury trial and reset your case, and that you did not fill out an application with the public defender's office. Is that correct?
Yes, sir.
Okay, well, now, so on July 31st of 2023, I'm putting up on the screen. Is that your name?
Yes, sir.
Is that your signature?
Yes, sir.
And you see where it was something was scratched out here, the 435 South Hill Street?
Yes, sir.
So it says, "It is my responsibility to hire an attorney or apply for the Public Defender's Office, ASAP," which stands for as soon as possible. The Public Defender's Office is located at 435 South Hill Street, Griffin, Georgia 30223, 678-688-8296. Are those your initials next to that?
Yes, sir.
Are those your initials all the way up these options?
Yes, sir.
So I don't understand what you want from me. I gave you the option in the courtroom to fill out an application. You didn't. I had you sign a document saying that you understood your responsibilities and that I was directing you to take action ASAP. This is January 8th, so it's now been 6 more months. And you're now asking me for an attorney, even though I've repeatedly, every time I've come into contact with you, notified you that you had this obligation to do it. We're here for trial now. Do you see why that's frustrating?
Yes, but the situation has changed.
Okay, what has changed? Help me understand why I should extend some grace here.
Just whatever you want me to do, sir.
No. I want you to convince me that this is a reasonable, this is your job to convince me that this delay has some sort of reason that is appropriate behind it, right? Not just that you decided you wanted to go home and sit on the couch and watch TV.
That's not, we had a house fire
That's the good, okay, now that's information that's helpful to me. Tell me that.
We
Sit
lost,
down.
we lost everything. This lady had a seizure. She told me to her apartment and we lost everything.
We lost everything in the house.
Everything.
That's the information I need. That's the kind of information that tells me that your life has been profoundly disrupted. And that's the kind of reason, if my house burned down, it'd be a lot longer than 6 months before I got myself back in order.
Today is the anniversary.
When did your house burn down?
Last year, January 8th.
Okay. Well, it didn't, it burned down before this happened? Okay.
No, this happened before that. But that's why I haven't done it. I guess what I was supposed to do, I could just do it.
Okay, here's what we're gonna do. I'm just gonna see you back here next Thursday, the 18th. I'm gonna talk to Mr. Shepherd in the public defender's office about this.
My witness just walked in, Judge, the witness.
You ready?
I hate to see a house fire, but that occurred 6 months before, 7 months before.
I know.
She came in for arraignment.
All right. So I'm catching that. All right, I'm gonna see you back here on the 18th. That's 2 weeks, 10 days from now. Go see the public defender's office between here and there.
Apparently my victim just walked in the door.
Yeah. So I'm